Chair.
Madam Chairman.
The meeting of the Committee of the Whole is now resumed. Leader of the House.
Yeah, thank you very much, ma'am. Madam Chairman, all the, as instructed, all the amendments have been circulated and exchanged, and we're ready.
Okay. So are we doing this clause by clause? Yes?
Clause 1.
Where we want to propose a preamble, whether we will deal with that at the end or whether at this stage, please, for your guidance.
The preamble is done at the end.
Thank you very much.
The question is that clause 1 stand part of the bill. The question is that clause 1 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 1 now stands part of the bill.
Clause 2.
The question is that clause 2 stand part of the bill. The question is that clause 2 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 2 now stands part of the bill.
Clause 3.
The question is that clause 3 stand part of the bill.
Madam Chair, the government has circulated proposed amendments to clause 3. May I, with your permission?
Please proceed.
Much obliged, ma'am. Madam Chair, we propose in the definition of criminal conduct to cause an amendment so that criminal conduct is an offense in Trinidad and Tobago. We delete those and we replace it with the words a specified offense. In paragraph B2, again, we're deleting the words an offense in Trinidad and Tobago and we're replacing with a specified offense. In the instrumentality of crime definition, we're proposing in paragraph A that we delete criminal and replace with the word specified. And if I may refer you, Madam Speaker, to the fact that in that same clause 3, the definition section has already a definition of specified offense. Specified offense has the meaning assigned to it by section 2 of the Proceeds of Crime Act. And if I may, for the record, indicate Section 2 of the Proceeds of Crime Act incorporates the list of offences set out in the second schedule to the Proceeds of Crime Act, which are those very heinous offences, murder, rape, kidnapping, etc. There is a reference in that schedule to taxation crimes, and we will treat with a limitation of that in a different clause. Those are the proposed amendments by the government and the rationale standing behind same.
Thank you. Member for Superior.
Madam Speaker, I'm very glad the Honourable Attorney General listened to members of the opposition because the definition of crime there in that clause that is now being amended was far too wide. Criminal conduct means conduct which constitutes an offense in Trinidad and Tobago. And we took serious objection to that. That's what is in the bill that we had until the amendments. And we took serious objection to that because it meant you could have had a DUI, you could have had a case for assault, you could have a case of Trinity. An offense would have been so wide so that we accept this limitation to crimes committed under the POCA, the Proceeds of Crime Act, and we will support that part of the amendment to clause 3.
Madam Chair, if I may.
Yes.
For the record, these were not observations that we gleaned from the opposition at all. These are observations which we brought ourselves. Secondly, there is no way on earth that the law as proposed in the bill could have included a cus case, etc. That is not the case, Madam Speaker, as the law specifically provided for. Thank you.
Okay. All right. So there's agreement on the first proposal with respect to criminal conduct. Member for Superior, anything else? Yes?
Not on that specific point, but
Yes.
there are other items of clause 3 that we
Yes.
would like to speak to.
Please proceed.
We proceed? Okay.
Yes.
In clause 3, B, clause 3B, we have criminal conduct, we have criminal property, but then we have, if it occurs, part B of that same, sorry ma'am, part B of that same part of clause 3, under criminal conduct. A constitutes an offense, has now been amended. B is where I wish to propose that we delete if it occurs in a country outside of Trinidad and Tobago and would constitute an offense in that country. What we are saying is if an offense constitutes criminal conduct in another country, it will be the subject of the criminal laws of that country. And to include that in this law, we would run the risk of double jeopardy of a person having to face double jeopardy. Further, we wish to prosecute criminal conduct that would have occurred in another country. That is the purpose for the laws of that particular extradition. So we believe that this occurring in a country outside of TNT should be deleted from this clause 3.
All right. So, Attorney General.
Yes, Madam Chair. If I may, the standardization of extraterritoriality as it relates to offenses is across every single law of the books of Trinidad and Tobago. It's in the Anti-Terrorism Act, it's in the Dangerous Drugs Act, it's in the Proceeds of Crime Act itself. That's the first point. Secondly, the double jeopardy is trite law in the Commonwealth, and there is no way that someone could ever be denied the defense of saying that he or she is subjected to double jeopardy. That is across the Commonwealth, and in fact it finds itself in the Mutual Assistance in Criminal Matters Act insofar as there is non-Commonwealth cooperation there. So we respectfully cannot agree with the recommendation. It would be to change the approach that this country has taken to laws since 1962, Madam Speaker.
Member for Superior.
Yeah. Honourable Attorney General, if I am to be penalised or tried in Trinidad and Tobago here, or go through matters under this present bill if it becomes law and when it becomes law, if something is done by a person outside of the jurisdiction, how can that be investigated here? How can that be dealt with as a breach of our laws?
Chair, may I?
What jurisdiction do we have?
I thank the Leader of the Opposition for the observation, and if I may explain quite simply. Madam Speaker, when we're treating with money laundering, which this law treats with as a scheduled offence, money laundering is transnational. And for instance, in serious crime cases, fraud, etc., where the wire transfer occurs abroad, or where the criminal property occurs abroad, and then there is that whole concept of where the transaction started, in which jurisdiction, without which jurisdiction. That's to explain the circumstance in which, if we were to accept the non-extraterritoriality of this law, we'd be making a mockery of international cooperation for money laundering in particular. And I would think that that is obvious to most people. Secondly, Madam Speaker, it is for that reason in extraditable offences that the first hurdle that you must cross in extraditable offenses is that there is dual criminality. You are treated with the fact that an offense elsewhere has a similar action in Trinidad and Tobago. Now, Madam Speaker, if we accept this very dangerous recommendation coming at us, it means that we will not be able to catch transnational crimes for money laundering, for hiding of properties abroad, for hiding of the proceeds of crime abroad. And this government cannot and will not accept that recommendation, Madam Speaker.
Madam Chair, may I add to what the Honourable Attorney General has said? This also is designed to capture terrorist acts, because right now terrorist acts that we may want to prosecute people for or forfeit their property for are being committed outside of the jurisdiction of Trinidad and Tobago. And when you go on further in this piece of legislation, under, for example, recoverable property means criminal property, terrorist property. So this falls squarely within our attempts to combat terrorist acts that are conducted by locals outside of Trinidad and Tobago.
Okay. All right. Should we, well, what I'll do is I'll take all the amendments proposed for the clause 3, and then we would put the questions. So we take the discussions. As far as the opposition, leader of the opposition, I believe you have some other amendments for clause 3.
Clause 3, yes, Madam. I propose that we insert in clause 3, Director of Public Prosecutions means the Director of Public Prosecutions of Trinidad and Tobago or any person assigned by him for the purpose of this act. This would do two things, Madam. It will allow for delegated authority, and there's precedent in the Proceeds of Crime Act, for delegated authority that is not the Director of Public Prosecutions himself, but any person so assigned by the DPP for the purposes of this act. I so move, I circulate it for clause 3, ma'am.
Attorney General.
Madam Chair, this is a recommendation which really is not objectionable, but also not necessary. The definition of the Director of Public Prosecutions, including the fact that he can lawfully delegate to his subordinates, is contained in the supreme law of Trinidad and Tobago. It's in the Constitution. And all laws are subjected to the supreme law, which is the Constitution. Section 2 of the Constitution makes that abundantly clear, and this law is read under the Constitution. So to define the DPP, I mean, really takes us nowhere, because that would say that the Constitution doesn't prevail.
No.
So Director of Public Prosecution means the DPP or any person assigned by him for that purpose. That's in the Constitution. And it's in the Interpretation Act. So quite frankly, it's superfluous.
Member for Superior.
No, Madam Chair. This is a formula that has been used in the Proceeds of Crime Act. This gives, for these sort of quasi things that are going to be happening, neither fish nor fowl, criminal nor civil, I think it is important that the DPP be so designated as himself or any person assigned by him.
Madam Speaker, that's true.
There's nothing objectionable, as the AG has said, and I think out of an abundance of caution, I would prefer to err on the side of caution than to go with the proposal being made.
If we wish to harmonize with the Proceeds of Crime Act, because it is defined there, then that's, I mean, that's why I said it doesn't go one way or the other. Sure. It's superfluous. There would be no harm in including it, subject to the views of the committee.
Correct. If I may just assist, EG, I would be very cautious on that, because what we then do is we're no longer harmonizing the law. And as you are aware, and anyone who practices in the courts, once you say the Director of Public Prosecutions, the Commissioner of Police, etc., it does not necessarily mean the person in post and in office. They can delegate their duties. For example, where it talks about the Director of Public Prosecutions laying charges, it does not mean only the office holder in the position of Director of Prosecution can lay charges. When we start making these kind of amendments across the board, it can lead to difficulties in further interpretation.
Okay, so.
Madam Chair, it's superfluous. It's already captured.
All right. Okay, so I think discussion on that has been exhausted. Member for Zaporia, I believe you have other amendments.
Yes,
proposed.
in clause 3, in the definition of criminal property, I suggest that we delete the words constitutes and replace with the word is criminal property.
AG?
Madam Speaker, the intention behind the definition of criminal property, which is now properly anchored only in specified offences, Madam Speaker, because remember, criminal property is read in the manner that we have proposed, right? But constitutes is a broader definition which captures the various iterations and combinations of events. And constitutes is to keep it synonymous with poker. So the proceeds of crime legislation uses the proceeds concept, and I think that we would be rewriting the manner in which this is interpreted. And what I want to make a specific cautious approach on, I don't want this to be read as constructively amending the Proceeds of Crime Act. So I prefer to leave it in tandem with the language used in the Proceeds of Crime Act.
Member for Superior?
The AG has the final say, Madam.
All right, yeah, I believe you have other amendments?
To clause 3.
Yes.
Still dealing with criminal property.
Madam Chair, before the leader moves on, please, in that clause, criminal property subclause A, as I read it over from a wordsmithing point of view, the word and as it appears in the third line is not necessary. So criminal property means property which constitutes a benefit to a person from criminal conduct or represents such benefit in whole or in part. The word and should be out, whether directly or indirectly, including. I'm so advised by the CPC's department.
Right. So, Member for Superior?
Yeah, the AG has stopped me, but that is exactly what my amendment is. The next amendment is exactly to delete that word and, whether, and replace it just with the inverted marks. I'm referring to item number 5, yeah, item 5, clause 3. Yes, that is the amendment that I've circulated.
Well, not quite, Madam Chair, because she's invited us to go further and delete the word whether. I don't agree with the whether. I agree with the word and.
What's that?
Okay, so that in terms of this, and I'm calling it opposition 4. AG, what you have agreed is that the word and comes out, but whether remains.
Not for 4, for 5. So,
Well,
so opposition
we haven't taken
5?
Preamble. Number 1 on theirs is the new preamble.
I see. I'm just looking at their list that's circulated. It's listed as 5. So on their 5, clause 3, in the definition of criminal property, delete the word and. I respectfully decline to delete the word whether and replace with the word comma, not necessary. So I would just simply say delete the word and, full stop.
Yes. Okay, Member for Superior?
Last word is on the other side. The government will have its way.
I believe you have other amendments on clause 5.
We don't have all week. We have on the clause 3, Madam, item 6, in the definition of criminal property, delete the word alleged offender and replace with the word respondent.
Madam Chair.
Attorney General.
We wanted in the definition insofar as a court must construe legislation with a presumption of constitutionality there, being very loath to disturb the presumption of constitutionality. We wanted in the definition to convey that this is an allegation. It brings into it the spirit and feeling of innocence until proven guilty, and therefore we would respectfully decline the invitation to simply categorize it as respondent.
Member for Naparima.
Attorney General saying that the concept of the word respondent implies guilt, is not constitutes the same thing as alleged.
Certainly not what I'm saying. I'm saying that in the rule of interpretation under the doctrine of Pepper versus Hart, it is important for the Hansard to reflect Parliament's intention. Parliament's intention in keeping in the definition section by using the reference to allegation is to imbue and bring to life the concept of innocence until proven guilty. And therefore, we want to purposefully color that expression by inviting a court to always be mindful not to rush ahead unless due process is had.
Yes, Member for Superior.
I was stunned for a moment.
Sure.
Because throughout the bill, the word that has been used throughout the bill is the word respondent.
That is correct. That is in the bill, not the definition clause.
No, in your
Just a
bill.
minute.
Your
Member for
definition clause is in your bill. Your clause 3 is in your bill. And throughout it, you have not said anything about allegations. In fact, these are some of the things that we raised on the opposition side when you were going with people who were not found guilty of anything, who were not charged with anything, being respondents. So throughout, I would respectfully say, Honorable Attorney General, that you have used the word respondent.
May I?
And therefore, in keeping with that, dealing with criminal property, again, it will be property of a respondent. It wouldn't be Mary's property and John's property. It will be a respondent.
Attorney General.
Madam Speaker, Madam Chair, the constitutional courts of this country, all the way up to the Privy Council, always look to the construction of the law. They must interpret the law as produced by Parliament. The definition section is a critical section which categorizes what you want. If we were to accept the invitation of the Leader of the Opposition, then we would have to use the word alleged right throughout the bill. That is why you have a definition section. It is here and only here that the coloring of the innocence and allegation needs to be had, nowhere else. To adopt otherwise would make a mockery of the manner in which law is drafted.
Member for Laventille West.
Thank you, Madam Chair. But in addition to that, in disagreement to the member for Superior, this talks about an approach where a criminal investigation is taking place. When you make the actual application, you're talking about a respondent. But we're talking about a criminal investigation leading to the civil application. I disagree with her.
I would like to agree with the Honorable Attorney General, but in the reverse, that in my respectful view, it's a mockery of the law to use these words, alleged offender, instead of the word respondent, when the entire bill deals with respondents in matters.
If I may, Madam Speaker.
The government will have its way.
All right, just 1 minute. Member for Oropuch West, did I see your hand? No? Member for Naparimo.
As a layman, I'd like an explanation on the specified offense.
Okay, just let's deal with what is before.
Yes. It uses the words unlawfully acquired wealth of the respondent. This is on page 6, so I'm just wondering for consistency across.
Sure.
Why not, So
that Attorney General, if you can deal with the
both yes,
and therefore,
sure,
I
Madam
think
Chair.
we would have.
Yeah, Madam Chair, with the latter contribution of Naparima first, that is the definition from the Proceeds of Crime Act. We don't wish to move away from that. Secondly, if we accept the Leader of the Opposition's invitation, we would not use the word alleged anywhere else in the law. Nowhere else in the entire bill would we have the allegation and therefore the coloring of innocence until proven guilty. So we would just chop it clean out, which would be, respectfully, creating a disaster from an interpretation point of view.
All right, member for Diego Martin Ortiz.
If I look at Part A of the definition of criminal property, it speaks to criminal conduct. So it's criminal property means property which constitutes a benefit to a person from criminal conduct. So this entire thing flows from criminal conduct. So you must have an offender, an alleged offender, if you're talking about criminal conduct. That is the root of the clause. I'm afraid I can't understand the problem because this is dealing with criminal property which is derived from criminal conduct. So you must have an alleged offender. A respondent is more properly belongs in the civil arena. We have a claimant and you have a respondent.
When the application is made, the point is the respondent becomes a live creature when proceedings have been filed. You see, until proceedings are filed, you're in a pre-engagement exercise. When you're in court and an application has been filed, that's when the respondent is clothed as a respondent. Someone, for instance, is not a defendant until they're brought before a court. Until then, it's all a proposition.
Member for Superior?
I do not accept the explanations. Government will have its way.
Okay. I think you have some other amendments proposed under clause 3.
Yes, madam. We have at item 7
Yes.
of my proposals, in the definition still of criminal property, I respectfully suggest that we delete the word suspects and replace with the word has reasonable grounds to believe.
Attorney General?
So, Madam Speaker, this is an important point to clarify. The reason why we have used suspect here ought not to be confused with what actually happens along the way. As this law is drafted, as this bill is drafted, investigating officers have suspicion. It must be reasonable suspicion. That's to be found in the comparators, for instance, in Section 32 of the Proceeds of Crime Act. That's to be found where someone goes for a warrant to enter premises or to seize things, or where someone actually arrests someone. That suspicion does not take care of the event. When the suspicion happens, you go to the Director of Public Prosecutions on the first route. You must then, the Director of Public Prosecutions, as you see later, must have the view that there's sufficient evidence. So the DPP goes to, from suspicion, the DPP says there's sufficient evidence. And when you go to the provisions in sections 31 onward, suspicion, DPP must have evidence, then the court goes to have reasonable grounds. So it is not at all the correct process to say mere suspicion, because when the court acts, it's filtered through the DPP who has sufficient evidence, and then the court accepts reasonable grounds. So this cannot be and ought not to be sensationalized as mere suspicion. That's not the way this law operates. And in the concept of criminal property falling on criminal conduct being only for proceeds of crime specified offenses, it makes it even tighter. So there is no turpitude or error or mischief in using the word suspect, because that's not what a court acts on. A court acts after the DPP has said that there is sufficient evidence, and where the court says there are reasonable grounds for acting.
Member for Superior?
I think, I know the AG intends to come to amend, I think it's clause 31 or 31.2, with respect to sufficient evidence and insufficient evidence. Take out insufficient and instead put sufficient. But I think he's mixing up his clauses, because this is not about the process starting from suspicion, moving to, what was it, evidence before the DPP, and then before the court. This is speaking to the alleged offender. The alleged offender knows or suspects. It's nothing to do with that process that you're going through to get whichever order at the end. This is about the offender, not about the DPP, not about the policeman, the DPP, etc., etc. So this is where the person, the alleged offender, that you had alleged wherever, the alleged offender knows or suspects. So that is a person. We didn't put offender. I asked to put respondent, he told me leave offender. So it's me, it's you, it's anyone who is being investigated on suspicion. Step 2 goes to DPP, DPP on evidence, then goes to court. No, no, no. This is a person must know, the person must suspect, constitutes or represents a benefit. So we are giving a sort of a discretion that the person has reasonable grounds to believe that this property is so tainted, has reasonable grounds. Look, Madam Speaker, in our country there was an allegation of a high official who sold his motor car to Dolce, for example, many years ago. And the money he would have received would have been the proceeds of Mr. Chedi, deceased, of his crimes. At the time when that happened, would that person have known, and now it would have got, if he's passed away, that official, it goes into his estate. Are you going to, will that be property recoverable from an estate? If it is that the alleged offender had reasonable cause at that time to believe that it was okay. This money was coming from an okay source, and that's why I'm saying it gives a protection to the person who is being investigated, that they must have reasonable grounds to believe. Yes?
Attorney General, wait. Let me just take the others on your side. Sure. Member for Laventille West.
Madam Chair, the alleged offender, he is in possession of what is being deemed criminal property. All that is required here, and what this is accurately saying, is that it is property that he knows or ought to know on some very limited evidence is criminal property. And I think this construction here and what is being suggested from the member for Siparia, very much similar, doesn't make any real difference. But just for the record, and in fairness to a former parliamentarian, there was no allegation that the car was sold to any drug dealer, but to a car dealer called Subans. Just to protect the reputation of someone.
General, please. Member for Diego Martin, Northeast.
Yeah, I just want to correct the record. In that particular case, the person, the former MP who is now passed away, had no possible chance of suspecting that because that person was not involved in the transaction. In this particular case, it's if somebody comes to you with a valuable property or valuable item and offers you a Mercedes-Benz for $1,000 or something like that. Clearly, in those circumstances, a reasonable person would suspect something is wrong. And this is what this is all about. You should be able to suspect that something is wrong with the property when it comes to you. That is the root of this. So I don't understand what the problem is again.
Madam Chair, please.
Just 1 minute.
Yes.
Let me just let the Attorney General.
Thank you.
Because they are all responding to a point that you raised.
Correct.
Attorney General.
Number one, the law must be read as a whole. Number two, Madam Speaker, criminal property does not mean it is recoverable property. This law is built, and civil asset forfeiture and explain your wealth is built only in respect of what is deemed to be recoverable property. Recoverable property is specifically defined, and recoverable property, you'll note, is in a section all by itself. It's in a clause 7, because the law has said that if you want these kinds of things to be operative, as we saw in the anti-terrorism law, put it in a section by itself. So when you get to recoverable property has some significant exceptions. Bona fide purchaser for value without notice of the crime is a complete exception. So to say that criminal property and the use of the word suspect is difficult makes a mockery of how the law works, which is why I've started off with saying you must read the law as a whole. Just because it's criminal property does not mean it is recoverable property. And that's the crux of this law. So dissecting it in this fashion here makes a mockery of the law.
Member for Siparia.
So criminal property is not necessarily recoverable property.
Exactly.
And then the reverse follows.
How?
Recoverable property has to be criminal property. It can't be anything else.
Madam Speaker, human beings may be arrested, but not everyone is arrested. They must fall within a category of having committed an offense. So we say something is criminal property, but it will not be the subject of a civil asset forfeiture order or an unexplained wealth order unless it is recoverable as defined under the Act. And that is to be very specific about this. You see, Madam Speaker, I must be careful on the record to disabuse and reject out of hand a narrative that on mere suspicion you're losing your property. That is not the case. And it is draconian and irresponsible to say that that is the case. I'm saying, Madam Speaker, I'm not talking about my members opposite.
One minute, please.
Let's
have a discussion where we hear each other. Yes,
I'm talking about narratives beyond the Parliament, and one would be foolish not to pick up on those narratives. I'm saying where there is a peddling of talk, irresponsible talk, that on mere suspicion your property gone, that is to be rejected. The property must be recoverable property. And the definition of recoverable property and what can be recovered is in clause 7 of the bill, Madam Speaker. And by the way, for the record, this is equivalent to section 45 of the Proceeds of Crime Act. So this definition, where the alleged offender knows or suspects constitutes, that has been the law as passed by a UNC government since the year 2000.
Member for Superior?
Yes, ma'am, I don't buy the arguments being put forward. I still think the Honorable Attorney General is mixing up the prosecution process. And when he talks about suspects and goes to stymie what he calls narrative about you can lose your property on mere suspicion. As the bill stands, yes, that is possible to happen. AG has now put an amendment which we have not got to yet. And I still think he's tying up that suspicion of the investigator, the DPP, and the court. This is where the offender suspects. And I'm asking that person who may or may not become the subject of all these orders here, that person be given the reasonable benefit of the doubt, that be amended to say, has reasonable grounds to believe. Even Member for Diego Martin noticed inadvertently or deliberately did say that he didn't have cause then to believe.
Which is the same thing.
Because it was a different person. I didn't call any names, so I don't know which case you're speaking of. So, sorry, ma'am. The honourable member said, had reasonable cause. That's all I'm asking for a person who could stand to lose their property, that person must at least have that benefit of saying, look, that I had reasonable grounds to believe. Look, lawyers who practice, when a client comes and pays you money, what do? You go into a due diligence before you collect the fee. How far would you go? And then one day you find out, but wait, now that client who came in here last week and paid the lawyer, you know what? Look, they convict him for some criminal thing, So this money might have come from a criminal source. So give the person a chance by saying has reasonable grounds to believe.
Madam Speaker, would the word, not that I accept any of what the Leader of the Opposition is saying for the reasons that I've announced, but for the listening public, would the qualification of ought to know, knows or ought to know? Because then that gives a slightly different color. You see, this is the individual, him or herself.
Yes, a person.
It's not a prosecutor who has to prove reasonable grounds for something. But Madam Speaker, in my submission to this committee, I'd prefer to anchor this in the submissions of the Proceeds of Crime Act. This Proceeds of Crime Act is slightly different because there it is a prosecutor who is looking for reasonable aspects. Here we're putting this thing where the alleged offender knows or suspects. It's the ordinary interpretation of that. Suspicion must be based upon reason. One does not have suspicion without reason. So there is an implied understanding that it is reasonable. But in any event, the salvation for this is to be found in the fact that criminal property is not recoverable property.
Okay. All right. Yes, Member for Kamutu Mansinala.
Yes, I don't understand what the AG is saying, because when I read clause 7 of the bill, which wait. The Honorable Attorney General indicated that in order for you to understand what the recoverable means, that you would see it in clause 7, which the member indicated there are amendments. I don't see any amendments at all in the document. So this is why I just want to clarify what he just said, what the AG just said, in relation to where it is recoverable in clause 7. So I know that we are not at clause 7, but according to what the AG just indicated, recoverable for criminal property comes under that. And if we can, in fact, read over what he has said, utilizing the terminology that is in here, please.
Madam Chair, when we get to clause 7, that'll become clear. My point is that elsewhere, in relation to this, recoverable property is the only thing that can be the subject of civil asset forfeiture or explain your wealth. Nothing else.
Okay. Member for Superior, I believe you have some, about 3 or 4 of us. Huh? Yes.
Our item 8, with respect to clause 3, again, with the definition of criminal property, I suggest we delete the words a benefit and for which it is immaterial, who carried out the conduct, who benefited from the conduct, and simply replace it with the words, the proceeds of criminal conduct.
General.
Again, Madam Speaker, the definition of criminal property is intended to be wide. But I come again to the fact that that is not recoverable property. Recoverable property is very specifically managed. And also there are a host of exclusions as to when something ceases to become recoverable. So you're intended to have a wide berth, and a benefit is a material point because one cannot categorize property easily. There has to be a wide explanation as to what property is.
Member for Superior.
You know, it's very verbose. I know the AG speaks very verbose language as well. But all that means, all those words, what they mean, represents a benefit for which it is immaterial, who carried out the conduct, who benefit from the conduct. All that really means that the thing is, the property is coming from the proceeds of crime, of criminal conduct. So we could leave it as it is. Again, the government has its way. I do not agree. But the government will have its way.
Madam Speaker, this is born from case law, not verbosity. It is born from case law. I am sure that Malunid Senior, the member for Siparia, could understand that. So first of all, it's case law. Secondly, because there are live issues as to what proceeds are. And when one comes to disaggregate whether you are an accomplice or not, is it an inchoate crime or not, all of these are real issues in law. Whilst my friend might think that that is being verbose, that is just the law, Madam Speaker.
Okay.
3.
Yes.
In the definition of instrumentality of crime, I recommend that we delete the word includes, replace it with the word means. I think the law should be certain, especially where there are going to be sanctions consequent upon this definition. So we take out include, but it leaves it open-ended, and instead we replace it with the word means. This is what it means. So the law is certain, you know what will happen. We know the sanctions are there to follow. I think we want to be more certain in the law than to leave it open-ended.
Attorney General.
Madam Speaker, the manner in which one drafts these things is to use the word includes so that the law continues to speak. What is today an instrument may not tomorrow be an instrument. One could not contemplate a flashcard, a flash drive, digital mechanism, cryptocurrency. If we were to be specific in the law and rely only upon the Interpretation Act, we'd be coming back every 5 minutes to amend an Act of Parliament, Madam Speaker. And therefore, the fundamental principle in drafting is that the law must be allowed to grow and breathe. And therefore, we keep with the current methodology of defining things by saying includes.
Okay, Member for Nap.
Again, you know, this is inconsistency at the highest. In this very definition section, if I look at the same page I'm looking at, civil asset recovery means, civil asset forfeiture payment order means, consent order means, criminal conduct means. In every one of them, you have the word means. And you're saying you want to leave it open-ended because things may change. But when it changes, that must come, and you must change your law in order to, again, let people know that the law is certain, where criminal sanctions are involved, where you can stand to lose your property. I think the law should be certain and not left open-ended. Okay. I plead my case again. You have used it almost everywhere else on that very page in your definition section.
Madam Chair.
1 minute, please. Member for Naparima, do you have a contribution to make?
No, I support. The only concern I have is that includes in the hands of someone who is not circumspect. It can be abused. And therefore, I would prefer, if my property is involved, to know the law and be very specific about that. So I would err on the side of being specific rather than being on the side of open-ended.
Okay.
Madam Chair, the person to be circumspect is a judge. So that person is circumspect. There's not any and every person off the street interpreting the law. It's a judge. So Naparima ought to know a judge is very circumspect. Secondly, Madam Speaker, the leader of the opposition sat down on the Proceeds of Crime Act as a member of the UNC government in the year 2000. And we're now 19 years later, Madam Speaker. And here it is. Property means, I'm reading from the Proceeds of Crime Act, property means real or personal property, whether within or outside the territory, and includes. And elsewhere in that Proceeds of Crime Act, they use the word means. So I cannot accept respectfully the newfound exhortations of the leader of the opposition to just all of a sudden say what has been volunteered. I reject it.
Member for Port of Spain North,
thank
St.
you.
John's West.
Thank you very much, Madam Chair. Madam Chair, to add to what the Honorable Attorney General has said, anyone who has had to interpret legislation before knows that the definition section is the policy that drives it. And the use of includes, the member for Siparia is saying we're on instrumentality of crime, includes, and she's saying there are other ones that use means. But look on the other page. Reasonable living expenses includes. What includes the when you use includes, what it means is exactly what the Attorney General has said. You take a policy decision as to how expansive you want something to be or not.
Okay, a member for Siparia?
Yeah, the Honourable Attorney General talked about something from the Proceeds of Crime. Some words that you just quoted. Did you complete the sentence? Did you complete what you were reading? After
Proceeds of Crime Act?
After the word includes.
The point is it is includes. The
What
exhortation was to use the word a dash.
And what comes after dash? It includes, and it gives a list of things that it includes.
Madam Chair, I think I have answered this point. I don't think I'm going to change my answer on that.
Okay.
It is inconsistent.
All right, so can we move on? Member for Siparia. I believe the other item is instrumentality of crime. Attorney General, I believe you have a proposed amendment.
Yes, Madam Chair, I volunteered that at the beginning.
Yes.
So the amendment was circulated by us. We had then turned, after I did that, to the Leader of the Opposition's recommendations, which were on, and I believe that the Leader of the Opposition then goes on to number 10 of her list. We did number 9, instrumentality.
Okay, fine.
You just did number 9.
Yes, and
that was the argument includes
and
means, yes. 10, clause 3, in the definition of property, delete the words assets of any kind, whether tangible or intangible, movable or immovable, listed assets, and includes cash, and replace instead with real or personal property, whether within or outside the territory, and includes a right, interest, title, claim, shows in action, power, privilege, whether present or future, and whether vested or contingent in relation to property or which is otherwise of value. B, a conveyance executed for conveying, assigning, appointing, surrendering, otherwise transferring, or disposing of immovable property, whereof the person executing the conveyance is proprietor or possessed, or wherein he is entitled to a contingent right, either for his whole interest or for a lesser interest. C, a monetary instrument, any other instrument or securities, any business, a vehicle, boat, aircraft, or other means of conveyance of any description, and G, any other tangible or intangible property.
Attorney General.
Madam Chair, the first thing that jumps out at me after hearing the Leader of the Opposition talk about the precision of the word means is that the recommendation now has the word includes. I'll flag that. Second thing, what is absent, Madam Speaker, what is absent is cash. So why would one want to define property without a definition to cash when cash is defined in this section in the position? So if we accept the Leader of the Opposition's position, well, forget cash clean. Thirdly, we are keeping consistent our definition of property to include that of the type which we did in the Anti-Terrorism Act, etc. There can be no broader a definition of property than to say it includes assets of any kind, whether tangible or intangible, movable or immovable, listed assets, which we have defined in this bill, and cash, which we have defined in this bill. So there can be no broader definition than that which we have offered. It is to be found in umpteen pieces of law The most recent of vintage is the Anti-Terrorism Act, and this allows for evolving asset, particularly when you are treating with choses in action and also intellectual property of the type including cryptocurrency, etc.
Member for Superior.
Yes, Madam Speaker, when it is convenient, the government through its Attorney General refers us back to the Proceeds of Crime Act. When it is not convenient, the Honorable Attorney General forgets what the Proceeds of Crime Act has to say. And indeed, when he talked about the word includes, when he was reading for the Proceeds of Crime Act, when we had the discussion about includes and means, he was in fact reading from the Proceeds of Crime Act, but did not continue it, because after the word includes, this is what happened. These words that I'm asking to be inserted are the identical words of the Proceeds of Crime Act. And I'm saying that definition of property, again, to harmonize with that, as we've been saying all along, I respectfully suggest you have your listed asset, yes. You could have cash too if you want, but we go with this definition of VOCA for the Proceeds of Crime Act.
Madam Chair, the government intends to amend the Proceeds of Crime Act in two important ways. One, the definition of property, to harmonize it with what we're doing now. And secondly, to amend the schedule of offenses to include anti-gang provisions, gang-related offenses. We unfortunately couldn't do this in this bill because this is not a miscellaneous provisions bill, and we will be returning to the Parliament in a miscellaneous provisions bill to change the definition of property under Proceeds of Crime Act and to add gang-related offenses into the second schedule to catch specified offenses in that way.
All right, and Leader of the Opposition, I believe there's one more you have under clause 3.
Yes. I'm here now. We are under, I'm looking at item 11 on my list. In the definition of recoverable property, insert after the word crime, the words, but does not include property that was obtained in good faith for value without notice that it was recoverable property.
Attorney General.
Madam Chair, there is case law in particular coming out of the anti-terrorism jurisdiction experience, which says that when you put this caveat in the definition section, that Parliament is treating with it loosely. We have caught the exact mischief that the Leader of the Opposition has flagged in clause 7 of the bill. And let me read it out. And the reason we put it as a standalone clause, which will become a section, is to make sure there can be no doubt that people that have bona fide interests are to be protected and that it is not recoverable property. And if I may, in clause 7(9), and this is to give punching power to the law, in clause 7(9), where a person holds recoverable property and is able to satisfy the court on a balance of probabilities, a very low standard, that the property was obtained in good faith for value without notice that it was recoverable property, the property ceases to be recoverable. Let me stick a pin and say the concept of value there is not cash only. It is not only for purchasers. The value includes a deed of gift, which is natural love and affection. The value includes a settlement of a trust. It may be for valuable consideration, which is non-financial and which the law recognizes for good and other valuable consideration, good and valuable in law. So we've been very specific to put this in an operative clause so that the court could never catch the innocent people who ought to be excluded from this law.
Member for Superior.
I'm sorry, Madam.
Yes.
I would respectfully recommend that the amendment be made to clause 3 with respect to where you acquire property obtained in good faith for value without notice that was recoverable property. I would want to see this inserted here. The Attorney General has a different view, so be it.
Attorney General.
Madam Chair, it's important to bear in mind, if we just put that in the definition section, who's going to determine that? In what process? In what standard? If we just say so, where is the process of somebody saying and protecting someone in those circumstances. The only way that that could be done is pursuant to Clause 7, Subclause 9, where a court exculpates somebody and says, look, your property is not in that. You got it by a deed of gift. Your mother or your father left it for you for valuable consideration. If we accept this here, who's going to decide that and in what process? It is by far better to protect the person and clothe them with protection by a court saying you're knocking on the wrong door. Don't touch my inheritance. Don't touch my gift that my mother or father gave to me or my uncle or aunt. I'm outside that pot. And that's why we prefer to be more cautious with people's rights.
I believe that this is the part of the bill in which we should make it very clear that if you got something without notice, you have it, the property was obtained in good faith for value without notice. I don't think an inheritance will fall into good faith for value without notice.
No, it falls in any other just purpose, which is elsewhere in the bill.
Okay. So I still feel this is a place we can, in defining recoverable property, we take that outside of being recoverable property, where it's got a good faith.
Okay, a member for Diego Martin, Northeast.
Yeah. Is the leader of the opposition saying, again, this goes back to an earlier point about whether you suspect something is stolen goods or not. Are you saying that the person should not have any liability whatsoever for receiving property that is obviously the proceeds of crime? No, but in your proposal, you are saying you have the words without notice, eh?
Yes, without notice.
Without notice.
Yeah.
And that's what has caught my attention. You're saying that if you have property that you obtain in good faith for value without notice that it was recoverable, it means that nobody told you that this property was the proceeds of crime. That defeats the earlier clause about suspicion. Yep. It means that somebody could present to you something and it's obvious this is the proceeds of crime, but nobody told you. So if we go along with your definition, you get away.
Purposes with your Honourable Attorney General. He has just said he's taken like words or similar words and put flesh onto bone inside of it in Section 7.
I'm only talking about this clause.
Yeah, but
your recommendation with respect to a definition of recoverable property, and you are trying to get us to agree that recoverable property is property that nobody told you was the proceeds of crime.
It's not so simple,
well, explain.
Minister.
Please explain.
It's not that it told you. In the law, for example, if you're going to buy a property, if somebody had a lis pendens against a property, you would be deemed to have had notice. So it's not like they must tell you in your face. The AG could tell you in conveyancing law what happens. So say without notice is there was no way you could have known. There was no way you could have known. And so you have value. No, these are the words that they use. Because you have it again in Section 7 of the bill, which is what the AG is just saying.
You do what I said.
Okay.
Just move on.
So, I think all the amendments, the proposed amendments to Clause 3 have been dealt with, and therefore I'll now put the question. So the question is that Clause 3 be amended in accordance with the opposition's list, items 2 to 11 as circulated. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. The noes have it. I think the noes have it. The question is that Clause 3 be amended in accordance with the government's list of amendments as circulated, and in addition, to delete the word "and" from the definition of criminal property, A, line 4, between the words "part" and "whether." Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that Clause 3, as amended in accordance with the government's list, and including the deletion of the word "and," in the definition of criminal property, A, line 4, between the words part and whether, now stand part of the bill. Those in favor say aye. Aye. Those against say no.
Can you please remind me which clause we're dealing with?
We're dealing with clause 3.
Okay.
But remember, we had 2 lists of amendments. Yes. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clause 4.
The question is that clause 4 stand part of the bill.
Madam Chair, the government proposes an amendment to clause 4. Specifically, Madam Chair, in putting the ability to have a civil asset forfeiture regime and an unexplained wealth order regime operate, we have already accepted that that must be done only as it relates to investigations treating with the Proceeds of Crime schedule. In that Proceeds of Crime Act, in the 2nd schedule, there is a definition, there's an offense set out, which is tax crimes. And the government thinks that it would be inappropriate and disproportionate in light of the existing law in the Income Tax Act and in the Customs Act to ask people to go and find documents which they would have discarded after 6 years. The law as it stands in the Customs Act, as we amended last year, and in the Income Tax Act, which has been decades in operation, is that if there is no assessment raised against a taxpayer or in the customs regime within 6 years, that after the 6th year, you no longer need to keep your documents. There's a positive obligation on taxpayers to keep documents for 6 years. It is imperative, therefore, insofar as clause 4 applies to crimes which may have been committed in the purview of this law prior to the proclamation of this law, that we only ask people in the tax regime and insofar as it hits in the customs aspect of that, because remember, customs treats with that indirect consequence as well, that they only be responsible for 6-year period behind the proclamation. So if we proclaim the law on the 31st of December 2019, you go 6 years back and only 6 years. There's an exculpation completely for anything beyond the 6th year, backwards. So if it's proclaimed in 2020, you're counting 6 years backwards, and you're only liable to account for things within that period because it would be unreasonable to ask you to go and get documentation beyond that period. It is for that purpose, and with specific regard to taxpayers and people in the customs arena, that we propose to limit the operation of the applicability of this law, which is clause 4, in the manner circulated.
Member for Shogunas West.
Thank you, Madam Chair. AG, just a sense of clarification here. Are you saying now that it is only going to be confined to breaches of the tax laws and the customs laws, or is it going to be, cover everything else?
All taxes, direct taxes, VAT, PAYE, BIR, health surcharge, all of those direct charges, etc., in the entire suite of what is considered tax or customs, you can only go back 6 years from the commencement of the law.
So no other crime is being dealt with other than breaches of the tax law?
Correct.
Okay, so that therefore, and the retroactivity is confined to a 6-year limitation?
For tax purposes only. So for instance, murder, which has no statutory period, can't be put in. Fraud, which has no statutory period, can't be put in. And those things are discoverable as and when the police find it. Somebody may have murdered someone 30 years ago and took their property, for instance. Maybe that's something that happened. But the one issue, which is a potentially wide issue to a host of people in this country, is what about my taxes? I threw away my documents 6 years ago. I can't find documents in 2013 or 2012, as it may be. If you're in 2020, from 2014, you can't find your documents. So because there are hundreds of thousands of registered taxpayers in this country, We cannot place upon them any burden to go back beyond 6 years. We must keep it within the chain link that the law currently prescribes, because that's a rational and logical thing to do. People must not be exposed to that specter of worrying where they're going to find their tax information because they got lost or they got rid of it after the 6-year period.
But then, why are you imposing a heavy obligation on non-tax matters? Why? You're saying, okay, for the tax matters because the law says 6 years. But any normal human being who would have built a house 20 years ago, 5 years ago, 10 years ago, may not have any piece of paper, none whatsoever, in existence, so that.
But there's other evidence to treat with that. You're
putting, it seems to me, a heavier burden on non-tax matters. In other words, I do not support exempting the tax matters. I think they should stay.
Sure. Madam Speaker, Madam Chair, there is a compelling reason to change this to 6 years, because people
just tax matters.
Throw away their money. That's tax matters. Yeah. Let's deal with the other matters. The rest of the matters in the proceeds of crime schedule are what we call blood matters or money blood matters. Trafficking in persons, rape, kidnapping, money laundering, drug-related offenses. The reason for putting a heavier burden on those people, and as we intend to put gangs inside of there as well, is to really focus the country's attention on that type of crime, because that is what is killing our society. The average citizen in Trinidad and Tobago shouldn't be worried about whether he had his tax documents from 7 years ago, unless it's fraud. Of course, fraud, you could catch them there. In those circumstances, post-conviction forfeiture applies, not civil. If you breach the tax laws, line up in the court on a post-conviction basis and talk about your assets there. It's reasonable. If we were to impose upon people this thing to go and find their documents in a hurry that they burnt or threw out, etc., that would be causing pandemonium in this country. And we cannot do that to the regular tax-paying people of this country. However, when we're dealing with drugs, etc., they do not. Now, the leader of the opposition raised a very emotive and important point. The auntie or grandmother or old lady down the block who built a house X number of years ago, no court of law in the equity jurisdiction, which this law holds on to, could ever forfeit that person's property, because number one, that person must be within the Proceeds of Crime Act. If the granny was involved in drug offenses and there was evidence before a court that the DPP was satisfied with, well, then granny has some questions to answer. If granny was involved in trafficking in human beings, well, granny have some questions to answer. But granny who built a house, as we say in Trinidad, chirrup, has no questions to answer. Please.
What about the person granny got it from?
Yeah. Granny not having notice and got that for value without notice of the criminal activity is clean and clear. Granny is an innocent person in that matrix, and this law is very careful to protect granny, who may be a doubles vendor, who may be a small man on the street, or a big man, or people who inherited their wealth from their families. Those people have nothing to worry about because they are not in the Proceeds of Crime Act. They're not in trafficking, they're not in drugs, they're not in murder. They are not in that category.
Okay.
Member
Speaker, would you object with your amendment?
I have circulated item 12, clause 4.
Yes.
We are not supporting clause 4 at all. And this has issues related to the constitutionality of the bill. I think my colleague, Shogunas West, will deal with that.
Shogunas West?
Madam Chair, I think that the whole question of retroactivity in the criminal law and matters of that nature is really inappropriate in the society, and that therefore we are of the view in the opposition that this retrospective effect of this law is inappropriate, notwithstanding the objective of this law. The ordinary citizen must know at the time when they committed any act that they had that act had certain implications of a criminal nature, and that therefore to come after the fact and make it retrospective in effect, inappropriate.
Member for Port of Spain North, St. Anne's Well.
Thank you very much, Madam Chair. To respond to my friend from Chaguanas West, it is rather a remarkable proposition to suggest that a person who's engaging in criminal activity, for example, let's say tax evasion, at the time of engaging in criminal activity, they're not aware that they're engaging in criminal activity, and there may be consequences that will flow from their committal of crimes. That is a fabulous acrobatic performance by Chaguanas West here today, and it cannot, by any stretch of the imagination, and I did try, meet with any merit whatsoever. So a person who has acted criminally, they know that they're acting criminally, and the Attorney General has proposed, and we've accepted, the second schedule of POCA, which are serious crimes. These are not driving under the influence or traffic offenses, etc. These are serious crimes. Persons who are evading tax know that they're evading tax. And I use this opportunity, Madam Speaker, to tell the public that it is estimated that between $12 to $14 billion a year are lost in Trinidad and Tobago due to tax evasion. And that is one of the things that we're dealing with here frontally today.
Madam Chair, if I could refer to the Proceeds of Crime Act to deal with Chaguanas West's position. I'm looking specifically at Clause 2 of the Proceeds of Crime Act. Reference in this act to an act that would constitute an offense or criminal conduct includes a reference to an act or criminal conduct which would constitute an offense committed before the commencement of the act. So that's point number one. Point number two, Madam Chair, if we drew a line to say that this, except for tax, that this must only start from today go forward, what about all the people before the courts right now, or who are under suspicion right now for trafficking in persons, for murder, for drug-related offenses, who are involved in conspiracies to defraud, etc., as we have in financial crimes, money laundering? Why should they be allowed to walk around this country in that category? This would provide a get-out-of-jail card for all of them and what they have done. So this law, in its proportionality, is intended to attach to those blood crimes, as I call it, or money from blood crimes, as I call it, and specifically to step aside from the tax man, the VAT man, the health surcharge man, the NIS man, all of those people only 6 years back, because they have the records for that. That is the proportionality in this. Because we don't want innocent people. Look, nobody in this country is without sin. All of us as human beings have sin. People may have had errors, they may be innocent, but if they don't have the documents, that's the problem. And it would be irrational for us to ask people to have documents beyond 6 years for tax issues.
Member for Laventille.
My friend from Chaguanas West, I think what he was alluding to is a well-established and well-observed principle that you cannot create criminal law retroactively. So he is really saying that if something was not a crime at the time that it was done, it is in breach of that principle and wrong to charge somebody if you created the criminal offense after. But I think he's mistaken, because fraud and murder and all of these things would have been existing offenses at the time of the commission of them. And what you're doing now is attempting to forfeit property as a result of well-known and committed crimes at the time. So I understand the principle he's raising, but I don't think it bears relevance here. He's mistaken, misapplying it.
Yeah.
Attorney General, how far back would this retroactivity go?
Retroactive is retroactive. There's no limitation period on retroactive. except in relation to the tax issues which we've spoken about, because you keep records for a certain period. Look, fraud has no statutory period of limitation, right? And when you discover it, there's none. Column, excuse me, we've dealt with it.
Shagonas. Sorry, member for Caroni Central.
See, Attorney General, I am not concerned about the murderer or the fraudster or the convicted criminal who is caught in this. I am concerned, and we would be concerned, about the innocent person who can be trapped by this. And therefore, the issue I want to raise is simply in the issue of the acquisition of property for a person who is not convicted of any crime, who can be caught up by this legislation for confiscation of property. And I want you to explain to me how that would not be a concern and how the bill takes care of it.
I apologize to the honourable member. I was just having a small discussion there. Could I ask you, please, to just succinctly just repeat your question?
What we're concerned about is the innocent person who might be caught up in the system. That is to say, somebody who has purchased a property, has not been convicted of any crime, but the property is deemed criminal property. Where's the protection for that person in the bill?
Sure.
And how is that matter to be dealt with?
Sure, the protection.
In this concept of retroactivity, because the person would have purchased under the existing laws, not having done a search for criminality, sure. And therefore...
I can answer immediately.
Right.
It's in Clause 7, subsection 9. There is a complete exculpation for that type of person. That person had no way of knowing about that. Clause 7, subclause 9 says, where the person is a purchaser, where the person holds recoverable property and is able to satisfy a court on a balance of probabilities that the property was obtained, notice the word obtained, in good faith, for value without notice that it was recoverable property. In other words, then, I had no clue of knowing that this somebody had some crime before and they were predecessor in title, and four purchasers ago, it was that person. That person is not in the basket. There's a complete exculpation under Clause 7.
But Attorney General, this occurs, forgive me, I'm trying to understand. My property is taken. I am innocent because under Clause 9, I am innocent. But that takes, in our system, 2 or 3 years for me to prove that.
No, your property is never taken. The civil asset regime says, look, it could be frozen. And you have 14 days if it's frozen for the court to make sure you come to court. And not only you, anybody with an interest comes to court. And in the interest of justice, no forfeiture can happen unless a court hears from you first. So your property is never, quote unquote, taken. You cannot have your property taken in those circumstances. Only a court could change the title away from you to the state. Because that's what happens in forfeiture. The title goes away from you to the state.
So it cannot happen ex parte?
It can. There's no forfeiture in this act ex parte, none at all. The law is specifically designed to be inter partes, full stop. Clause 34, where an application, clause 34.3, within 14 days of a property restriction order being granted, that's in effect a freeze, right? Look, hold on to that property, don't do anything with it yet. Within 14 days of that restriction order being granted, not forfeiture, it says restriction, or such other period as the High Court may direct, notice of the order shall be served on all persons known to the agency and any person claiming to have an interest, etc. And then it goes further. At any point in time, if we didn't catch you, you can knock on the door of the court and say, hello, I have an interest in this thing. Reverse yourself. Make a further order. So there is never a situation of taking property. I just want to point something out. I saw an interesting video being circulated on the WhatsApp channels. It was Trevor Oliver from the United States who was talking about how seizures happen in the United States, where policemen catch you and you have cash in the car and they take your property for $40 and some crime. That does not apply in this circumstance here. That law in the United States is totally different from ours. There was no judicial process there. For this thing to be forfeited, a court has to say it is forfeited. And it is exactly the circumstances you would find under a Mariver injunction or under a Section 242 or 245 remedy, minority shareholder remedy, or other remedy under the Companies Act, by way of example. So this is, we are not the US. There is no indication of that. And anybody who does not have notice of this is completely outside of the matrix.
So Attorney General, 33.4, an application under subsection 1 shall be accompanied by an affidavit from the investigating officer. And 5, an application under subsection 1 or 2 may be made ex parte and without notice. What does this mean?
So read 6. It's for a restriction order, not a forfeiture order. Look, there are circumstances where the state, let's say a drug dealer is about to do something, where you may want to restrict the property. You want to seize it for a moment. It happens every day in court under Mariver injunctions, right? So under a Mariver injunction, you can go to the court and say, look, a fear that something's going to happen to that property, the bank account might be dissipated, the cash might be withdrawn, and you go and you freeze it under the provisions of the Mariver injunctions. That's equal to this. What happens next is an inter partes thing. 2 parties come to court, and in our case, it's multi-party. All people with an interest get to come to court. The mortgager, the lessee, the person who said, look, this is mixed property. That man, I didn't know he was a crook. I invested in this property. Look, my money inside that property. All of those people come forward and say why the court should not treat with that property. And in those circumstances, Clause 33, which is a restriction or freezing, is not the forfeiture mechanism. The forfeiture mechanism comes in Section 44.5, where the agency makes an application for a forfeiture order against recoverable property. It shall do certain things.
Member for Point Lapeer.
Chair. AG, just, we're talking about retroactivity and going back into time. Let's say you acquire a property 25, 30 years ago. To prove, and it says 7-9 kicks in. Now, currently Central is talking about innocent individuals. For that innocent individual, that person has to go to a court of law. And the process of going through that whole process of taking a lawyer and so forth to prove his or her innocence.
You wouldn't even get there. In the civil asset forfeiture regime, an investigating officer must go to the DPP must go to the trustee must go to the court, and it goes in the following graduation scale. Suspicion, reasonable suspicion, DPP must be satisfied there's evidence. If the DP is satisfied that there's evidence, the court must say that there's reasonable grounds. If they came and they said, look, Faris Al-Rawi has a property that he bought 40 years ago, 30 years ago. The record is in the court. Sorry, is in the registry. The deed for that property would have to be presented to the DPP. So before the DPP even said yes, the DPP would have a very hard time demonstrating how a 40-year-old deed came to relate to a money laundering transaction 5 years ago. So let's be rational in how we're approaching this thing. That's why we put in the filters. And the ultimate filter is the court. But for the DPP to even get there, and as you will see, this is further grounded in the fact that this is a specified offense under the Proceeds of Crime Act. So the drug dealer who's living in his grandmother's house, let's use that as an example. Granny don't know that the drug dealer is involved in activities. He's a good boy, as they say. He is caught in some drug-related offense. When they're going to go for a civil asset forfeiture order now, Granny's property not in that. Granny's property is in her name, acquired 40 years ago. The errant son or grandson who's in that property, or somebody who took over the property in a home invasion, for instance, that man does not have a right to have granny's property in the pot. So that's why I'm saying that this thing is so carefully built. However, if he has a BMW in his name, he has $300,000 worth of gold chain in his name, that's a different story.
Member for Laventille West.
Thank you, Madam Chair. And just by way of extension and example to the point so well made by the AG in terms of the concern for the member for Naparima, where the investigating officer, on making the application, he puts in an affidavit. He is investigating criminal behavior and he's identified property. And then he sees on Facebook or on some other form an advertisement for the vehicle that he's attempting to treat with. It is on that basis and in that affidavit that he goes to court and says the vehicle is now up for sale and I want a restriction order. That's how it works.
Let me give an example. I'm home and somebody plants cocaine in my water tank. Let's assume. Let's assume.
Okay.
And
Member for Naparima, don't.
Yeah. And an investigating officer in good faith discovers this. He gets 3 persons to swear, and they go to the court ex parte.
Question. In your example, sorry to interrupt, but I catch your drift. If you bought that property 25 years ago, as probably happened, right? Somebody in your station in life probably invested in property years ago. 20 years ago, 10 years ago, and somebody planted something in your property yesterday, and the police come and knock on your door. How are they getting past proving on reasonable grounds that the proceeds of that crime followed the property 20 years ago?
But my understanding, and again, forgive me if I don't, and clarify, that the crime is to the property, right? To rents. So therefore, the property has now become tarnished.
So we go back.
So the deed is irrelevant.
So it's the deed is very relevant. The definition of recoverable property is that it is something that flows from the crime. It's the proceeds of that crime. So you were selling drugs and you bought a car. That car could likely be from the proceeds of crime. It surely can't be that when 20 years ago you bought a property that a crime today could have paid for that. That's not the case. That property would be exempted from this. This law and the way it has been applied in other jurisdictions, take for instance the Antigua-Barbuda case. In that case, there was a man who, Ahmed, I forget his name, Williams or whatever it was. He was convicted of a drug offense. And the property that he had related to a time frame when he bought the property and he was selling drugs. If we look to the Harrods case, where the Azerbaijani banker was jailed and his wife was in England, she spent £16 million in shopping at Harrods. She bought a jet. She had a $12 million mansion and she had a $10 million mansion. And all of those things were bought in the time frame for which the husband was convicted for fraud in Azerbaijan. So those things are rationally connected. The old property that you bought, etc., is severable from the proceeds of crime. That's why we say the DPP must be satisfied that there is evidence that this recoverable property flowed from a criminal conduct under the Proceeds of Crime Act.
Bernie Central.
Yes. AG, the thing that we want to avoid is miscarriage of justice for someone who is innocent. If a matter goes to the DPP under this law, and the DPP has not yet pronounced, isn't it possible for the matter to be taken to court before the pronouncement for a property to be withheld, to be held, or to be, I forget what is the legal term, restricted in the law? Isn't that possible? Isn't that possible under the law?
Not under the civil asset forfeiture route. the trustee can only go to court and ask for a restriction order or a forfeiture order if the DPP says there's sufficient evidence. So there's no way you could apply under Section 44, Clause 44, for a restriction order under the civil asset forfeiture route unless the DPP says, I, the DPP, acting in my independent constitutional role, am satisfied that there is evidence, not suspicion. The DPP says there is evidence. Only then could they apply for a restriction, and then the restriction must go to all parties, and then everybody must have their say.
So DPP's intervention is necessary for a restriction order?
Yes, because the restriction order can't happen under the civil asset forfeiture route unless the agency is given the green light by the DPP to act. And the DPP must...
Where is the clause that says that?
Sure. So if you look to Clause 31, Clause 31, where during the course, and we have an amendment to this, right? Where during the course of a criminal investigation, and we're bumping up the categories, we're going to put controller of customs, controller of Board of Inland Revenue, and a policeman above the rank of inspector, right, has reasonable grounds to suspect that an offense involves recoverable property, he may forward an investigative report to the DPP. Then, subclause 2, whereupon receipt of an investigative report under 1, the DPP is of the view that there is insufficient evidence to pursue a criminal charge, but there is sufficient evidence that the property is recoverable property.
Okay.
And their recoverable property is not just any criminal conduct property. It's the type that excludes granny's home and the other factors there. So this here, Clause 31, subclause 2, only where the DPP says, green light, go, can the trustee, who's an independent appointed entity by the JLSC as to the first two, and by the leader of the opposition and the prime minister or the president in sole discretion if they can't agree, only then can they get to court.
And he makes this judgment on the basis of the balance of probability.
More than that, the case law demonstrates where a DPP says that there's sufficient evidence. Look at what he's doing first. He's really looking at a criminal matter. Right? So it's not light evidence he's looking at. He must first determine, look, I can't go criminally. That's serious stuff. He must have done investigations via these authorized investigating people, because it's only the police could investigate. He will usually send them, bring them back, receive their information, send them back. Now, he must be satisfied that there's not just reasonable evidence, there's sufficient evidence that the property is recoverable. To get to sufficient evidence, the DPP will have asked for the deed. So they can't just come up and say, hey, Faris Al-Rawi is living in X property. I don't like him. No, the DPP will call for the deed for the property, find out Faris was really renting the property, and it was owned by Colum Imbert. And then they say, well, hold on, that's Colum Imbert's property. That's not Al-Rawi's property. Come again. So this thing is not a speculative, difficult thing to follow. The DPP must determine that there's sufficient evidence that it is recoverable property, and Clause 7 says recoverable property does not include property which a bona fide value without notice of the crime involves. So there are significant safeguards inside of this.
So, members, I'm now going to put the question. I think this Clause 4 has been exhausted. The question is that Clause 4 be amended in accordance with the opposition list of amendments, item 12, as circulated. Those in favor say aye. Those, please let's have some order. Those in favor say aye. Those against say no. No. I think the noes have it. The question is that Clause 4 be amended as circulated in accordance with the government's list. Those in favor say aye. Aye. Those against say no. No. I think the ayes have it. The question is that Clause 4, as amended in accordance with the government's list, now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clause 5.
The question is that clause 5 stand part of the bill. We are now reached, we are clause 5. So the question is that clause 5 stand part of the bill. I'll call on the leader of the opposition. I believe you have amendments.
Thank you, Madam Speaker. Honourable AG, with respect to clause 5, I am asking you where we have put the president in the standard, where are you? Sorry, I have the wrong piece of paper. Give me a moment, please. Yeah, any question? Just one moment, please. I'm sorry. Yes, any question under this act as to be deleted, because if you're talking about the standard of proof, it has to be under this act, and therefore it would be superfluous, in my respectful view, to say any question under this act as to.
Madam Chair, I didn't have a view on this per se. The CPC tells me that this is the way that it is drafted. The point, the intention of this clause is to simply say this is civil standard. And therefore, any issue under the Act, any question, any subset ought to all be at civil standard. So the CPC's explanation to me is that in case there's a separation out of issues, let's not guess as to what standard applies. It's all civil.
I'm happy that we have, in fact, yes, express provision for the standard of proof. I'm just suggesting that it could only, the questions could only arise under this act. It will not be under any other act.
Well, I'm guided by those that draft as opposed to I didn't have a view one way or the other. All that I wanted to be sure is that the standard didn't change when the burden shifted. Because on one occasion it might be prosecution turned to defendant or respondent, and then vice versa, and there's an issue of changing of standards where reversals of burdens shift.
Member for Caroni Central, is this the clause you have a question on?
Yeah, well, it's a question that really has to do with the issue of standard of proof. And how does the issue of reasonable suspicion figure here in this clause, being not mentioned at all?
Sure. Madam Chair. So again, and I understand the need to work this out. Reasonable suspicion is the first step in the investigators. To get past that, they need, on the civil asset forfeiture arm, they need to go to the DPP, who has sufficient evidence. After you get to DPP, you go to the court, which says there must be reasonable grounds to do what it is doing. So that is a graduation aspect. The reason that we've gone for civil standard here is actually quite similar to the rationale for having a civil standard for money laundering. Under the Proceeds of Crime Act, the standard of proof for money laundering matters is on a civil standard. So, and that's on a pure criminal offense matter. So here where we're treating with this, we've gone on the civil standard. It's not uncommon or unknown to our law. It exists right there in the Proceeds of Crime Act.
Thank you, Madam Chair. But Honorable AG, you will recognize that the civil standard in the Proceeds of Crime Act takes place after there's conviction beyond reasonable doubt. So that therefore it is a second tier in the process.
Allow me to put on the microphone. Thank you. That's not necessarily so. So cash forfeitures, it used to be the case where forfeiture happened under Proceeds of Crime. It used to be the case prior to the UNC government in the last term changing the law that you had to have a predicate offense. We then took away the predicate offense for money laundering. And particularly in the regime of cash forfeitures, which is a considerable regime, we don't need a conviction. So that's not something that is necessarily wholeheartedly there. There are versions of it to be applied. And that's something that the country has been rated on by the Financial Action Task Force as a matter of fact. Its cash forfeiture regime in particular.
Okay.
And just to put it right, because I want to be correct, the forfeiture of cash, Section 39 of the Proceeds of Crime Act, the standard of proof in proceedings on an application under this section shall be that applicable to civil proceedings. We also have clause 45, subclause 4, for the purposes of subsection 3, the standard of proof required by the person referred to in that subsection shall be that applicable in civil proceedings. And subsection 3, where a person is charged with an offense under this section, and if the court is satisfied that the property in his possession or under his control was not acquired from income derived from a legitimate source, it shall be presumed, unless the contrary is proven, that the property is criminal property. So the Proceeds of Crime Act for cash and for property in Section 39 and Section 45, as it relates to money laundering, the latter one, civil standard and presumptions.
Okay. The question is that clause 5 be amended as proposed by the leader of the opposition. Those in favor say aye. Aye. Those against say no.
No.
I think the noes have it. The question is that clause 5 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 5 now stand part of the bill.
Clause 6.
The question is that clause 6 stand part of the bill. Leader of the opposition.
Thank you, Madam. Item 14, clause 6. AG, I may need a clarification here. Why is it that we are saying a property restriction order made under this act is an order in rem against property believed to be criminal property? Why on belief, and on whose belief?
So we're starting with the genesis of the thing which can fall into the order. And in describing that, because we're making it reference, we're making reference to criminal property, right? We're not dealing with recoverable property, which is a much narrower category. In treating with criminal property, we still at suspicion, because it's not yet recoverable. And what they're doing here is they're making sure that the in rem applies. And if you go to the maritime law, for instance, and you look at the manner in which you may seize a vessel, an in rem seizure against MVX, right? That is how you describe it. It's still believed. We use believe because it has not yet gone into the definition of recoverable property. But we're making sure that the moment we're treating with it on an in rem basis. Now, why in rem? So for those who are listening on, in rem means the thing in itself.
So will it be the state as against?
PCX 2434, a car, or the state against a room full of cash comprising X million dollars.
A container full of water bottles.
Correct. Whatever it may be, it's against the thing. Why? We want to be careful in this regime that we are not determining the guilt or innocence of a person, because a person's guilt or innocence has attached to it a deprivation of liberty. Because you'll be sent to jail, you'll have a criminal record, you may be denied all sorts of things. So all that this thing is treating with is a thing. It cannot treat with a person, which is why the Strasbourg courts, that's the European Court of Human Rights, and the English courts have upheld the constitutionality of civil asset regimes.
I was concerned about the insertion, not about in rem and so on. Property believed to be. Is it necessary that it is on belief? Simply that the property is believed to be criminal property, terrorist property? So
I'm so sorry. Would you repeat?
Yeah, my concern was not for the meaning of in rem. My concern was property believed to be
Okay,
criminal.
look at 6.1 and 6.2.
Yeah.
6.1 applies to a property restriction order. 6.2 applies to the forfeiture order. In 6.1, that's the ex parte You may not have everybody present. There's sufficient evidence. The DPP is involved. But at that point, the restriction is really on a belief and sufficient evidence of the DPP. It's only when you get down to a forfeiture order that we're saying is an order in rem against property which is criminal property, terrorist property, or instrumentalities of crime. So we use the belief insofar as it relates to a restriction, and we use the is when you're going for the forfeiture.
In that event, Madam, I will withdraw that particular amendment.
So the question is that clause 6 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 6 now stands part of the bill.
Clause 7.
The question is that clause 7 stand part of the bill. Leader of the opposition.
Item 15, with respect to clause 7.1. Attorney General, you were pains to point out and to clarify definitions in the clause 3 definition sections. Why are we repeating the meaning of criminal property, terrorist property, instrumentality, and so on is recoverable property? Why didn't we just say recoverable property is recoverable under the Act? And you have a definition in clause 3. Why is it necessary to do this here?
It came out of the experience in the litigation under the Anti-Terrorism Act, where the courts, not only in Trinidad and Tobago, but in equivalents elsewhere, poured scorn upon relying upon things which were in definition sections. So the current learning is where you want to be abundantly clear that you should put it as an operational section of the law, in this case here, clause 7. And what we're making sure, here is the important point. Recoverable property is as defined here, subject to all of the subsections in clause 7. In particular, the powerful protection by 7 subclause 9, which is where you're holding property and you obtained it for value in good faith without notice that it was recoverable, then you're out of that category.
With due respect, sir, then that makes nonsense of the definition section.
I had the same battle while we were amending the Anti-Terrorism Act, and I fought with assessors and I fought with the jurisprudence, etc., and I said I didn't agree with it. But the advice given to us was it is safer in the section itself as opposed to in the definition section, because it makes it absolutely clear that Parliament's intention was to define recoverable property in very specific circumstances as set out here.
AG, with due respect, it was identical to that in the definition section. As you define many other things, criminal property has been defined, recoverable property. I'm just saying there's no need for you to put it in the section. I can see no justification.
The need is to be in the position that when a judge has to apply this law, the judge has a whole section in the Act to say exactly what Parliament intended recoverable property should mean. And if you were to try to define all of the circumstances of recoverable property, then how do you fit in subsection 9? You see, it is in this clause 7 that you define, you go through what is not recoverable property, and you go through the mechanism by which a court tells somebody, you have nothing to worry about. This property is not recoverable property, and that's in subsection 9. So this is more than just defining. This has operational worth inside of it.
The words are identical, sir. The words are identical. So it's not that you're excluding, including, or stretching. So let it go. I don't agree, but so be it.
Can we go on to your other
we are on to
proposed amendments on clause 7?
Yeah, clause 7.7.
7.6.
7.6.
Sorry, 7.6. Minor suggested amendment, 7.6, where a person who has criminal property, and my suggestion is that we should put where a person who has an interest in criminal property.
So, Madam Chair, we treat with criminal property, first of all, as a categorization. Then we treat with the manner in which criminal property may be held. Joint tenancy, tenancy in common, equitable interest as opposed to legal interest, etc. That's why we've come further down to say what mixed property is, what an interest in property is, and how you treat with it from a severability point of view across the various species of property, which may be tangible, intangible, and real or in personam or in rem property, right? So what we start off here with is where a person who has criminal property, what we're catching here is the generation of profits from criminal property. But later on is where we disaggregate mixed ownership from joint ownership, from equitable ownership. Because take, for instance, where somebody owns stocks or shares in a company and they own it as part of an ESOP plan. How are we going to treat with the ESOP plan disaggregation? Or where there's been an assignment of the beneficial ownership to a spouse, which is constitutes an irrevocable assignment, for instance, where you have alienated yourself from the gift, as can happen in certain types of trust arrangements. In all of those categories, what we're trying to treat with later on is that disaggregation. But here, the mischief we intend to legislate for is capturing the profit from it, so that when you have the equity of tracing, that you also trace the profits generated from it.
All of that is fine, but you're saying where a person has criminal property, how do they have it? Are they holding it in their hands? Or is it they have an interest? And it's all those things we just said, joint interest, whatever, it's an interest.
Right, so criminal property is defined as property which constitutes a benefit to a person from criminal conduct or represents such benefit in whole or in part, and whether directly or indirectly, economic gains included, funds or property converted or transformed in their property. So the interest is captured in the definition. So if you have criminal property, the first thing you got to go and see is, well, what is criminal property defined as? And criminal property is defined as constituting a benefit or interest in same.
The person must have an interest in that.
It's captured in the definition section.
He has this phone. I'm suggesting
he may be in possession of the phone. The legal owner might be his company.
Where they must have an interest. You've helped me, in fact. And where a person has an interest in the criminal property.
And it is caught in the definition section.
You know, sometimes I know you're working very hard today. In fact, you seem to be, they've put you on the line as the only person, and you're working very hard.
It's my job. All of my colleagues are equally capable of handling this.
You're working very hard, sir. That's exactly what I'm saying, that it should be an interest, where the person has an interest.
We agree.
Whether it be part, whether it be some joint, whichever way it may
don't
be.
Take the beat.
It cannot just be has.
We agree. It's in the interpretation section.
We move on. The inconsistency of being in the interpretation section or not being in the body. That's what we've been doing all evening.
Right, so close 7.7, I believe.
7.7, which is item
17 on your list.
Yes. AG, I have asked for B to be deleted, C and D, because I don't understand how it flows from what is being said at 7, before the sub ABC. 6.7, which says, recoverable property ceases to be recoverable under this Act, and let's take B. If pursuant to a judgment in civil proceedings, the defendant makes payment to the claimant, or the claimant otherwise obtains property from the dependent. Can you explain how that will make it no longer recoverable property? It will cease to be recoverable.
Sure, because the person was acting in respect of property which would otherwise be recoverable, but they acted in accordance with a direction of a court. And therefore, the court is an intervening effect to stop it being recoverable. So this takes care of somebody acting outside of subclause 9. In subclause 9, we exclude the bona fide purchaser or bona fide owner for value without notice. However, we must also exclude somebody who received the property by virtue of a court order, because the court intervened and said, go and give that property to someone else. So I must put an equitable and lawful stop to the tracing of that property, and I ought not to go behind an order of the court, because the court exercised a determination of rights and said, go and give that property to John Brown, who sued you for it. it would be improper for the tracing to follow past a court order, which is a final determination by a court of law.
Honorable AG, I think this may be a recipe for fraud. Opening a doorway for fraud. For example, all a person will have to do is bring a fictitious claim for a property and transfer pursuant to such a claim being made. And it will then not become recoverable property.
You're right. And that would be
a divorce settlement.
And that would be a proper recipe if there wasn't a remedy. You can set aside court orders which are by consent or by way of final operation on 3 important grounds. Apart from the appellate ground of a superior court saying the inferior court was wrong, there are 3 important grounds. 1, mistake of fact. 2, material misrepresentation. And 3, fraud. So in those circumstances, you can disturb a court order. There's proper case law on this. Mistake of fact, material misrepresentation, or fraud. So there is a remedy to treat with that.
Well, with due respect, in our jurisdiction, I might be dead, so maybe you and many of us before the court reaches to that point, because the matters are so stacked and backlogged for a long time. I think this
it's been dealt with multiple times before. I have dealt with this in court on many occasions.
Who will set aside who will set aside that judgment? Yeah, the court cannot on its own motion.
The court
Someone will have to approach the court.
Listen,
someone will have to approach
so here's
the court.
how this goes. For something to be recoverable property, the court must, when it is analyzing assets, let's say the court is treating with Stuart Young. Stuart Young is before the court. They realize that there is property in his portfolio, which could be recoverable property. They say, right, you see that property in Maraval? We want that property because it fits all of the reasons why it should happen. And then somebody turns up and says, hold on, I sued Stuart Young for that property and got that property and a court ordered it. So let's assume that that was a fraudulent arrangement. It was a cook-up deal. Boy, sue me and I wouldn't defend it and he'll get a judgment in default and he'll take the property. Right? So let's assume that that happened. It would be up to the civil asset trustee to say, hold on, that was a fraudulent scheme for the following reasons, and ask the court to set aside that award. Because if we were to not have this position here, the thousands of cases of vesting of property by a court on a daily basis in the civil regime. Remember, a court determines property rights all the time in the civil regime. People may go forward in a civil court and say, I want you to cause the registrar general to set aside a deed because that deed was based on fraud. So this civil asset route is not unknown to our law. It's the first time we're codifying it in one place.
No, we're not going there. I'm saying this, yes, this is opening a door, in my respectful view. Someone is going to have to set it aside. You're saying the civil, this court, through these court proceedings, that court can then move to set aside something. I'm saying by that time it will be long gone. It will be years before any such thing happens. And so it opens the way for fraud. So if X has recoverable property, all the person has to do is to get someone to sue them. Yeah? You get somebody to sue them, and when the property is transferred, it ceases to become recoverable property. That is what this means.
Madam Chair, the honourable member is correct. There are live examples of that that have passed. SIS did that in the Eden Gardens matter. It's not in court. I'm giving you an actual example of a case where that happened. So this is a known scheme. Correct. Well, I wouldn't talk about that because that's still on, right? But these are things which happen all the time. And the point is, if we were to cater for it legislatively in reverse, everybody would be paying for one person. It must be that a judgment of a court stands as a judgment of the court. And that if you want to disturb a judgment of the court, go to court and disturb it in the normal way.
Member Federico Martin notices you still want to make an intervention.
Madam Chairman, if the Leader of the Opposition is concerned about 7(7)(b), then why isn't the Leader of the Opposition concerned about 7(9)? Because to me, the principles are the same. in 7.9. No, but you have not proposed an amendment to 7.9. Yeah, but you have not proposed. We are on clause 7. We are on clause 7. And you have not proposed an amendment to clause 7.9, which means that you agree with the principle that where a person holds recoverable property and is able to satisfy the court on a balance of probabilities that the property was obtained in good faith for value without notice that it was recoverable property, the property ceases to be recoverable. So you agree with that legal principle. And that is very similar to what the Attorney General is bringing in 7.7b. So you're contradicting yourself.
With due respect, that it's not happening. And I beg to differ. Why are we moving then to legalize something that we know is fraudulent? It is not the same.
That is not the case,
Madam
Chair. Let me be careful. This is the committee stage and we're on record. There is no circumstance where we could be legalizing fraud. We are setting the well-known established principle that there are certain estoppels, in this case a legal, it's more than an estoppel, a legal stop to positions. You cannot go behind a court judgment unless A, it is turned over on appeal, or B, it is set aside on 3 grounds: mistake of fact, material misrepresentation, or fraud. You can go behind it, but you must be careful to have evidence to do that. You ought not to be able to have a legitimate thing. If we remove this, Madam Speaker, then everybody who went to court and had a judgment of court, every mortgagee sale, every order for possession which a court went through, that means all their property would be in the equity of tracing. It means everybody in this country that bought a property from a bank sale should start to panic because the order of the court wouldn't be final. I mean, this is a most astounding submission on the part of the Leader of the Opposition. It is to worry the entire banking sector and mortgagee sale arena. That would be madness, intellectually speaking, of course, Madam Speaker. Madness.
I think it is equally madness to put this particular provision in there, in 7b. Given what we have said before, I do not agree. And my colleague Notice raised the issue of 7.9. That does not arise when we are looking where property will become not recoverable property, ceases to be recoverable property, where something like this takes place. I beg to disagree, and let us agree to disagree.
Madam Speaker, when you're doing a title search, part of your title search, after you get to a root of title, which is defined in law as to what roots are good roots, you work your way forward and you check. One of the things that you do if you see a judgment which has been registered is you ask for the satisfaction of a judgment. If there's no satisfaction of a judgment by way of a filed notice of satisfaction discoverable in a court of law, you're in trouble. If we accept Siparia's recommendation, it means that every title search for the last couple hundreds of years will be in trouble. And it would be feeding the same paranoia that is being put out in the public domain as to why people ought to be worried. I am genuinely concerned to understand what is being said here.
All right, so can we move on? Member for Superior, I think you have C and D also under.
C, if the AG be kind enough to explain why this would make recoverable property no longer recoverable, please. 7C.
So 7C says, recoverable property ceases to be recoverable if the claim of the claimant is based on the criminal conduct of the defendant. Let me explain that. John Brown goes to court and sues Jane for fraud on the civil route, not the criminal route, because criminal matters may take forever. And people go to court all the time and they seek to rectify the title, the register, and say, listen, this was fraud. And they go on a balance of probabilities and they get the property overturned on the basis that this was fraud. So there ought not to be a circumstance where you didn't provide for this. If we're dealing with here recoverable property, we're dealing with the concept of what we call the equity of tracing. So in tracing the property, you have to stop tracing if somebody else sued for that being fraud. because they got there before you. They sued before you. So they were first in time, they before a court, and they're telling the court, no, 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 that's my property based upon somebody's criminal conduct in a civil court. And it is therefore only fair if you take the ranking of priorities that that person has first bite at the cherry.
Honorable AG, again, I see this as an avenue for fraud, as an instrument of fraud. If the claim of the claimant, which claim are we speaking of? Which claimant are we speaking of? Which, based on the criminal conduct of the defendant?
So, Madam Chair, assuming this law is proclaimed, and assuming that this law, when proclaimed, will meet an ongoing legal system, a judicial system with umpteen matters of cases before the court, if we were to automatically say, well, hold on, Jane Brown, who was selling drugs, that property is now properly recoverable property because she is in the poker proceeds of crime specified offenses. Forget the claim that somebody else brought in advance where they were asking for something, then that causes problem. We have to respect the fact that the law will be applied onto a system which is ongoing, and therefore you ought to preserve the priority of claims. So it could be any claim.
Again, but we agree to disagree on that one, and then similarly with 7.
But Madam Chair, sorry to interrupt. What I could say is that in C, the word "the" ought to be changed to "a." Because what Siparia just said is sensible. Which claimant?
Are you sure?
Yes, that aspect is sensible.
That's good coming from you.
If the claim of a claimant.
That's why I asked you, which claim? It is still ambiguous, Honorable Attorney General. Huh? It is, maybe you could.
What I could say as well, Madam Chair, perhaps this may help to alleviate some of the concerns of the Leader of the Opposition. This comes from the Commonwealth law. So the Commonwealth model, the 22 other jurisdictions that we've looked at, all of these provide for these as the recommended best-in-class mechanisms to ensure that people who got there first are treated in the priority that they ought to.
Honorable Attorney General, I'll have to fact-check that because many times things are said. That is not necessarily the case. When you talked about the 22 other jurisdictions, well, we did look at some of those after you talked about the umpteen jurisdictions and so on. And there are differences, obviously, across the various models.
Of course there are differences. So we didn't say that we applied 22 laws in pari materia. How could we?
Can we go to 7D, please, Madam? I disagree with you. I say, again, with D, 7D is the same point. It is the same point.
D says, if civil proceedings have commenced and the property obtained by the claimant would be recoverable property, again, it is to recognize the priority of who got there first. We're saying, let a court hear that first. If a court decides otherwise, it falls back into the pot, you know. It falls back into the property being potentially recoverable property. But let those who got there first have their matters heard first.
Again, I see this as another avenue, Madam, and so we agree to disagree. I think this should not be there, so I'd ask for B, C, and D to be deleted from 7.
Just for clarity.
Yes, please.
Would the word "the" before claimant remain, or is that changing to be A?
It should be A. In subparagraph C, 7C.
Yes, but in D, does it remain "the" or it's A?
It remains the.
There? Okay.
Because that's in civil proceedings, any civil proceedings.
You see, AG, I think you were onto a good thing there when you in response to the question, which claim and so on. I'm suggesting that even in D, it is a little confusing because we have claimants here, we have claims here, but there'll be matters ongoing here. And I'm not sure, now I'm understanding it a little better. Now we realize these are outside things completely from outside of this act.
Correct.
But I don't find that is clear enough in the way it's worded. Maybe you can ask your drafters to look at it.
Madam Chair, I confess, it took me 4 or 5 goes at this to make sure I understood it right while we were drafting over the years that we took. And so it is a term of art, but a claimant is the terminology used under the civil proceedings rules for civil proceedings, so I had to use that.
Initially, you had the claimant, which you've now changed to a claimant.
But that's in a different circumstance. In C, if the claim of a claimant is based, in D, if civil proceedings, that could be any civil proceedings, have commenced, and the property obtained by the claimant in any civil proceedings. So that makes linguistic sense.
Then we beg to disagree, Madam. We agree to disagree with respect to 7.
D.
Well, 7, C, D, E. B, C, and D. Yeah, all 3, I think they can be used in a way that will not belong to the benefit of the Act. All of these proceedings are indeed civil proceedings that we have here.
Okay. So, is it that it's been withdrawn? No.
No.
So the question is that clause 7 be amended as proposed by the leader of the opposition. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that clause 7 be amended as proposed by the Attorney General. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 7, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clause 8.
The question is that clause 8 stand part of the bill.
Other amendment to clause 7(8) rather than clause 8. We had
at 18.
18, yes, madam. 18, 7(8). No, she didn't call this one. It was not called.
So how are we going back to that now?
Item 80, madam.
Okay, so what I'll propose to do is let's revisit clause 7 and we will just take clause 7(8). Okay? So the question is that clause 7 be revisited. Those in favor say aye. Aye. Those against say no. I think the ayes have it. So we're looking now at clause 7(8), leader of the opposition.
Thank you, Madam Chair. Insert after the words criminal conduct the following words: only where there is reasonable grounds to believe that the grantee had knowledge that the property was recoverable property. This will go in tandem with the 7(9) that the AG has spoken about. So if a person grants an interest in recoverable property belonging to him, the interest is also to be treated as obtained through criminal conduct only where there are reasonable grounds to believe that the grantee had knowledge that the property was recoverable property.
Madam Chair, it's caught by 7(9). So 7(8) tees it up, it holds it as recoverable property, and then that person is exculpated in the circumstances suggested by the language of 7(9).
Leader of the opposition.
I do not agree, because in 8, if the person grants an interest in recoverable property, which is different from where a person holds recoverable property and you can show good faith without notice and so on. So I think the two provisions are different, and respectfully recommend that we insert this at the end of 8.
Madam Chair, 8 creates the effect of tracing. So similar to the previous subsections where we traced profits, we traced other things, 8 says, if a person grants an interest in recoverable property belonging to him, the interest which he granted is also to be followed, right? The Honourable Leader for the Opposition spoke a little while ago about circumstances of fraud and was making the argument in respect of subclause 7 that B, C, and D allowed for fraud because somebody could sue you and then that stops you. Well, if we were to treat with 8 without following it in a strict sense, we'd be feeding the same argument of mischief offered in respect of subclause 7. So 8 is intended to trace that property, the grant that happened. It may be an equitable grant, it may be a leasehold interest, it may be it may be a trust, it may be different things. In 9, we say where a person holds recoverable property. That's the grantee in 8. So the grantee in 8 says, listen, I'm holding that. I leased that property for 99 years. I paid for it. I paid my money. They didn't give me a deed for it yet, but my equity prevails over my law, and therefore I own it. That person comes under subclause 9 and says, I, on a balance of probabilities, can prove that I acted in good faith, there was value, and I had no notice that it was recoverable. So 9 is how you catch it.
Okay, fine. Again, Honorable Attorney General, I beg to differ and propose the amendment circulated.
All right, so the question is that clause 7 be amended as proposed by the leader of the opposition. Those in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that clause 7 be amended as proposed by the Attorney General. Those in favor say aye. Aye. Those against say no. No. The ayes have it. The question is that clause 7, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clause 8.
The question is that clause 8 stand part of the bill. The question is, Leader of the Opposition?
Clause
8. There's no amendment.
No, there is none for clause 8.
Okay? So the question is that clause 8 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 8 now stands part of the bill.
Clause 9.
The question is that clause 9 stand part of the bill. Leader of the Opposition.
Clause 9, suggesting, this is where we give the qualifications of the second deputy trustee, and we have asset recovery as one qualification, asset management or finance and audit. I want to suggest all be included.
Attorney General.
Well, the civil asset trustee and one of the deputy civil asset trustees shall be attorneys at law of at least 10 years standing, appointed by the President on advice of the GLSE, with experience and qualifications. In other words, stick a pin, they have law already, and they've been doing it for 10 years. And the GLSE considered them and said, you're a lawyer for 10 years, so you have experience in law, you're in the boat. Then we go further to say that you should have experience and qualifications in the following areas: asset recovery, asset management, or finance and audit. So it's taken care of already. Is it? Well, so is it that that amendment was intended for subclause 2 in the manner that I just read, or is it with respect to subclause 3? Because the proposed amendment doesn't say which one. Huh? The second deputy trustee shall be a person who possesses qualifications and experience in asset recovery, asset management, or finance and audit. That one does not require law. Yeah. But the circular for clause 9 doesn't say which one of them we're looking at. Which one is it?
3.
So
we're looking at a wider pool, AG.
Right, so finance and audit or law.
Yeah.
Yeah. And you could have written.
So that you could, so you're widening the pool.
Yes.
That would be agreeable if it's in that particular section.
AG,
yeah.
Wouldn't you want to make sure you have somebody with finance and audit? Because
yeah,
if
but
you add law, then you may not have somebody with finance and audit.
No, I understand, but in the circumstance where you might find a pool very small, you run into those problems in appointments of people sometimes where you just can't find people to meet the muster,
Correct.
and you may be forced to use 3 lawyers. So I would have no difficulty with that.
Thank you.
See, let's see, out of 19, we finally got you to.
All right. So,
yes.
All right. So the question is that clause 9 be amended as proposed by the leader of the opposition. Those in favor say aye. 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 Those against say no. I think the ayes have it. The question is that clause 9 as amended now stand part of the bill. Those in favor say aye. 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 Those against say no. I think the ayes have it.
Clause 10.
The question is that clause 10 stand part of the bill. Leader of the opposition.
I beg to move this 10.1 be amended. The civil asset trustee, the term of appointment, instead of 7 years, for it to be 5 years. Yeah, the procurement
I was just asking, I was just literally asking the Minister of Finance his views on that. Is it to keep it in harmony with the public procurement?
Somebody,
hello?
Member, could you just step out of the meeting, get your phone under control, and you can return.
The voice song's out of control.
The chairman has exclusive authority over this domain. So, Madam Chair, I went for 7 to make sure that somebody had tenure. I mean, there's a comparative to the public procurement law. I have no difficulty if the committee feels that it should be a lesser period. In the public procurement law, we went for a lesser period, and that's an institution of equal standing.
Yeah, that is even a more.
Yeah, no problems, Madam Speaker.
Okay, and with that.
Haruka has a problem.
No, because no. I do not have a problem with 5 because in the urban and regional, yes, we said 5.
And they quarreled.
And they quarreled and said it wasn't enough time. It should be 10. So I'm surprised that they're saying 5 now.
What's
10-2, leader of the opposition.
Comment with 5 now. 10-2, moving along. 10-2. Civil asset trustee again, term of appointment instead of 6, we replace it with the same 5.
Could I ask whether the leader of the opposition is thinking, I have no objection to amending, right? But what if we make everybody coterminous, then the issue of continuity falls to be considered. You know, is there any institutional memory left inside of there?
You could make it less.
So would
you
4...
can make it slightly less.
Yeah?
Yeah, for the deputy person, maybe it's slightly less.
4?
11.
For clarity, what is agreed as far as 10-2?
4 years.
4 years?
Yeah.
Okay. The question is that clause 10 be amended as proposed by the leader of the opposition in terms of clause 10.1 to replace 7 with 5. And as agreed in case of clause 10.2 to replace 6 with 4.
Yes.
Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. The question is that clause 10 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clause 11.
The question is that clause 11 stand part of the bill. Leader of the opposition.
I beg to move clause 11 be amended as circulated at item 22. What this is saying here is that a person appointed as a civil asset trustee or deputy civil asset trustee, no person is bankrupt if it's a bankrupt on some mind. But then I see in C, which is the one I want to move the amendment for, has at any time had a record of criminal conviction for any offense which carries an imprisonment of at least 5 years. So I would want to say it should have no criminal record whatsoever.
Attorney General?
I don't know.
I welcome the suggestion, but what crossed my mind was somebody with a DUI with a longer term, which is why we went to the 5 years. I don't know if the law is going to be changed at some point in time. Sorry to put it this way, but there's some offenses, like under the Summary Courts Act, I mean the Municipal Corporations Act, the sale of rotten tomatoes is an offense. And I don't know what the law is going to happen later on, so I wanted to not have somebody with those kinds of offenses excluded. So this is sort of standard in many places. I don't know how the law is going to evolve. I don't know what time frames are going to be changed to. So what we had gone for has at any time had a record for indictable or summary which carries a term of imprisonment of at least 5 years. Sure, please, I welcome.
Oh. I'd like to make a suggestion. Yeah, there is a particular law where bathing in the Maraval River is an offense, which is a term of imprisonment. I would like to suggest we look at the Representation of the People Act, where you can't be a member of Parliament, and I think it's either 1 year or 2 years is the term of imprisonment. If you have been sentenced to prison for 6 months, you can still be a candidate and a member of Parliament. But once you go beyond a certain amount, you're disqualified from being a member of Parliament. And I would suggest we use the same rubric.
Sorry. When we did the NPO bill, and you talked about the disqualification of the individual holding, controlling, how does that relate to this individual at this position?
We put a higher bar just like this. It wasn't just anybody, controller had any offense. Obscene language offense would be ridiculous to debar somebody for. So those controllers, we harmonize that with the Companies Act existing provisions.
With due respect, AG, if I may, Madam, with due respect, you know, this all that we're doing here, and we've been here, and you spent 4 years drafting this law and so on, I think it is just too important. It is one designed to deal with criminals and criminality.
So no offense?
No. For this particular, well.
But what about the DUI guy?
What about the RPA, Minister Imbert is speaking of? I'm not
12 months.
But I'm not agreeing to that. I'm not agreeing for this. It is too important.
Okay.
The whole purpose of this thing is crime and criminality.
Sure.
And you're saying, okay, man, you could have had it for, it's 5 years, you know. So you're now suggesting maybe 1 year.
I'm not suggesting that. Just saying that is
To
a good
look at that
standard.
formula.
We could look at that as a standard. It's 12 months.
So Section 62 of the Representation of the People's Act disqualifies a person from being a member of Parliament if it's been 12 months.
I'm not agreeing. I'm suggesting the person should not have a criminal record. This is too important.
You see, my fear in this is that there are very innocuous offenses in law. DUI, which may be slightly over, could be in that. Rotten tomatoes, in all seriousness, bathing in the Maraval River. There are some offenses which don't go towards an issue of corruption or impropriety, but in respect of which there may just be an offense.
So we are putting a lawbreaker.
Yeah.
For whichever offense, we want to put a lawbreaker to be a civil asset trustee.
So suppose he was caught.
Deputy civil asset trustee.
Suppose he was caught with 1 joint of marijuana, and we go to decriminalize that in the future. And that happened when he was 17 years old. As children make mistakes, is there no room for improvement of one's character? I'm being serious. People make mistakes in life. None of us have not made mistakes. I certainly am far from perfect or without sin.
Yes, and I'm happy that the AG raised
AG,
that.
let us go to the
Madam
RPA.
Chair.
12 months?
12 months. Sorry.
Thank you, Madam Chair. And I'm very happy that the AG made that rather potent point. I thought I had detected a philosophical underpinning when the member for Siparia in the NPO legislation spoke using the example of a certain person as a controller for an NPO. But now I'm realizing that that was then, and she has a different philosophical approach on this matter now about criminal conviction.
Member Leader of the Opposition.
Madam Speaker, I think we can find a compromise. There is precedent in our law, and that would be
1 year?
The 1 year.
Sure. I welcome the suggestion.
Oh.
Why is that fellow so offensive, though?
Members.
Talk about Naparima sooner.
Members for the committee. Okay, let's please maintain our composure. All right, so at least 1 year?
Yes, please. Yes, Madam Chair.
If you could just read that over for me, please. Just make sure.
Yeah. So Madam Chair, in clause 11, in subparagraph C, it would say, has at any time had a record of criminal conviction for an indictable or summary offense, which carries a term of imprisonment of at least 12 months. So instead of 5 years, 12 months, which would keep it in line with the RPA Representation of the People's Act.
All right. So the question is that clause 11 be amended to delete the words in clause 11C. Delete the words 5 years and substitute the words 12 months.
Yes, ma'am.
All in favor say aye.
Aye.
Those against say no. I think the ayes have it. The question is that clause 11, as amended, now stand part of the bill. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it.
Clause 12.
The question is that clause 12 now, clause 12 stand part of the bill. The question is that clause 12 now stand part of the bill. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. Clause 12 now stands part of the bill.
Clause 13.
The question is that clause 13 stand part of the bill. Leader of the Opposition.
Thank you. As I understand it, if we do not insert the words, the President in his own discretion, what this would then mean is the Cabinet, AG. That is my recollection of it.
Yes.
And therefore, I beg to move that we insert, after the word President, the words in his own discretion. That way, it is the will of the President, not the Cabinet. Yeah. Well, you really, AG goes a little further. I mean, this is where the President may at any time revoke the appointment of a trustee.
I have no objection
it should
because
not be the
we
Cabinet.
took the formula of the President in his own discretion doing something.
Thank you.
We took that caution. I would have no difficulty with that.
Good, let's move it along. We're doing better as we go.
So the question is, we now have to go to 24, which is in 13. We at clause 20, at item 24, which is also clause 13.
G, again, this power for the President to revoke the appointment of a trustee, and we are told when, but the G says for any other reasonable cause. I think that is far too wide a power for revocation of an appointment of a trustee, and it would be ambiguous to leave it like that. This is what the President may, in sole discretion, and this is not the person of the President. So, I mean, no disrespect. It is the office of the President to revoke an appointment for any other reasonable cause. I mean, that is probably how you draft, but I think it is too wide to revoke somebody's appointment for any reasonable cause.
Since we are changing this now to the President in his or her discretion, I think we need to trust the President. Because this is reviewable, you know, as we learned with the Max Richards case. This is reviewable. So I would leave it.
Madam Chair, I think that we would want, I welcomed the fine-tuning of the President's discretion as recommended by Siparia. I think that we need to allow the room for the President in own discretion. There may be some other compelling reason that's just wrong, that doesn't fit the circumstance. So I'd recommend that we leave it.
You see, another compelling reason could well be that this person is not doing what I want them to do. I'm not going on the person. I'm speaking of the office. You will see above, you have misbehaves in office, brings his office into disrepute, becomes a person with disqualified. These are very strong grounds for revocation. This comes like the power to appoint as well. This is a very dangerous thing in my respectful view. You were very careful in crafting how you would set the thing up. You were very careful how appointments would be made. I respectfully ask you to reconsider deletion of 13G.
In many bits of legislation, if a person does not attend meetings for a particular period of time, their appointments can be revoked. That's not in this list. You see, this list is not exhaustive. We could put 10 things inside of here and think that we've covered everything, but we may not have covered everything. I think the word reasonable qualifies it. The President will have to be reasonable.
I don't agree, you know, because that will accord with the power to appoint. Is the obtuse or the reverse of a power of appointment that you have the power to disappoint.
Yeah, that's in the Interpretation Act, so yes, that's permitted in law.
And therefore, so to do, that's what I'm saying, that's what the power is, so to do on G, which I respectfully say is far too wide.
You see,
and therefore
with the greatest of respect to the member, I thought that the example given by the Minister of Finance was compelling. So somebody who just decides, look, I'm not coming to work and misses all of the meetings could not fall within the list that we have. And I think that if we're giving this discretion to the President, we ought to at least leave a little room for latitude, particularly because the caution is that the President can be reviewed at law, as the Max Richards decision clearly demonstrates.
Beg to disagree, sir.
So the question is that clause 13 be amended as proposed by the Leader of the Opposition at item 23. All in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 13 be amended as proposed by the Leader of the Opposition as item 24. All in favor say aye. Aye. Those against say no. No. I think the noes have it. The question is that clause 13 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clause 14.
The question is that clause 14 stand part of the bill. The question is that clause 14 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clause 15.
The question is that clause 15 stand part of the bill. Leader of the Opposition.
Item 25, clause 15, to delete the words reckless and knowingly. This is in 15.2, please, madam. A person to whom this section applies who recklessly and knowingly fails to comply with subsection 1 commits an offense. It should be a strict liability, and we should take out recklessly and knowingly. The clause is too important to provide a statutory defense in this way for such a person.
AG?
Yeah, I was looking. Madam Chair, I'm looking for a judgment which was just issued by the Privy Council. Just permit me 1 second. Yeah. There is a case coming out of Mauritius. It's a Privy Council decision. Just looking. I don't have it here. But anyway, the latest authority coming out of the Privy Council on this concerned a Minister of Finance who was the Deputy Prime Minister in the state of Mauritius, who ran afoul of disclosure of interest. And the court specifically read into it the requirement for a mental intention, which included knowingly. So in that law, there didn't appear to be animus mens rea element, and the Privy Council said, no, that is definitely not the case. You have to read the mens rea element in. And they had held it to be in the context of recklessly and knowingly. So if recklessly is causing some issues, then we should certainly keep knowingly at the very least.
I beg to disagree. If we look at it, this is about integrity in public life. This is about disclosure of interest in matters. I think it should remain a very strict, it should be kept very strictly and not give a statutory defense to a person who
well, you see, that's what I'm saying.
Who breaks, you know,
so the 2019...
Let's have one contribution at a time.
So,
Member Superior, are you finished?
Yes, ma'am.
Sorry, Madam Chair, Privy Council judgment published on the 25th of February 2019, which is persuasive authority for us and binding authority if we get there. Lord Carr, Lord Carnwath, Lord Lloyd-Jones, Lord Kitchen, Lord Sales. This is from the Supreme Court of Mauritius, Director of Public Prosecutions versus Jugnauth and another, who was the Deputy Prime Minister and Minister of Finance. They had the exact words, if we delete this, recklessly and knowingly, and the court put it back in because they said it would make a nonsense of the circumstances. And this is the leading authority on this, which was exactly on point with this. So that would mean that I would have to ignore the decisions of the Privy Council, which I'm aware of, and I just can't.
I disagree. I have not seen the judgment. I do not want, I'll have to fact check it. I'm very sorry. I have not seen the judgment. But where we are dealing about conflict of interest issues, where a trustee who, you know, for the purpose of connection with exercises functions, the whole property enter into contract, sue and be sued, employ agents, execute power of authority, deed other instrument, power to do any other act. I mean, they're given tremendous powers of assets that would have been recovered. And I do believe that we are giving such a person a statutory defense.
Well, Madam Chair,
where they are in breach of the conflict of interest and of disclosure of interest.
Madam Chair, the Privy Council, February 2019 decision insists upon a mens rea being present. And when we put recklessly and knowingly, it's to catch more than just knowingly, you know. You may have been reckless as to whether it happened. That's an important qualification. So having recklessly and knowingly catches a wide category of issues because reckless is a by far lower standard than knowing. So we respectfully disagree with the Leader of the Opposition on the basis of Privy Council authority.
May I also assist you?
Yes, Member Fidego
I just
Martin.
did a very quick search, and I would refer the Leader of the Opposition to the case of King versus Victor Parsons and Company, 1973, 1 WLR 29, and also Beeman versus Arts Limited, 1949, 1 King's Bench 550, where Lord Denning, he explained that to the word knowingly, you must add the word recklessly, because, and I will read it, a man is aware that what he is doing may well be wrong, but he takes the risk of it being so. And that's where the recklessly comes in. So this goes back to a 1949 case.
Okay.
The
Privy Council has affirmed it.
All right. Yeah. So can we go on? Leader of the Opposition.
You can fact check all you want. It's there.
We have some other amendments on Clause 15.
Clause 15.
Item 26.
26, please. Unless he proves to the satisfaction of the High Court that he did not know that the matter in which he had an interest was the subject of consideration by the agency, or he had an interest in the matter under consideration by the agency. Again, I think this is giving the same reason, basically. You're giving a statutory defense for a person who would have breached the integrity provisions with respect to disclosure where there's a conflict of interest matter. So I would respectfully ask that these statutory defenses be taken out.
Madam Chair, let me explain why I can't accept that respectfully. I don't want anybody to fly off the handle. I'm going to put this in an hypothetical structure. No, I never would. Let's assume that you're sitting as the Prime Minister of a cabinet. You're a person in public life under our Integrity in Public Life Act. You make a particular decision. You award a particular mandate which has with it certain benefits. Surely that person ought to be able to have the right to go to court to say, look, this thing has been done before. Because otherwise, if I were to apply the existing laws of Trinidad and Tobago in certain circumstances, crap will smoke your pipe. That person ought to have a right to go to court. And I'm speaking about real examples that I could speak about elsewhere. So we must be reasonable in these circumstances. There's a very real large elephant in the room on this issue. And we can't be halfway on it. I think you catch what I'm saying.
I don't think the speaker catching anything right now.
I know you caught me.
I didn't catch you.
You will.
Well, I will. You probably know something I don't.
It's in the public domain.
And let's not go into
yeah,
that.
let's try not to go there.
I don't know what it is, but I am
It's
saying,
the award of silk.
I am saying, oh my God. There you go again. I think you're just jealous.
Breach of the Integrity in Public Life Act.
All right.
Just jealous.
Okay, members. Members, let's get back on track. Member for Diego Martin Northeast. Member for Diego Martin Northeast. Member for Superior. Attorney General. Let's get back to the business of this. I think you made a particular point in response. Let's forget the last matter there. Member for Superior, if you could just address your amendment, please.
Yes, I'm suggesting that these words be removed as on the circulated list of amendments.
Okay, so
I suspect 23 million.
I'm now going to put the question. The question is that clause 15 be amended as proposed by the Leader of the Opposition. Those in favor say aye. Those against say no. No. I think the noes have it. The question is that clause 15 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Clause 16.
The question is that clause 16 stand part of the bill. Leader of the Opposition.
As circulated at item 27, please delete the words at 16(2). No civil or criminal proceedings shall lie against its trustee who in good faith discloses information as permitted under this Act.
Madam Chair, can I ask why?
Well, why do you want no proceedings against someone who, a trustee who discloses information?
Because we want this person to have the absolute indemnity in the strictest sense possible, to act without fear at all for doing the right thing. Because if this person is to be fettered in any way, we were very careful in constructing this law to make sure that this trustee was appointed by no politician, the JLSE, the president in own discretion if the Leader of the Opposition and Prime Minister couldn't agree. We've agreed that if you're going to be removed, president by own discretion. But we want to make sure that this person has the protection to know that they don't need to look over their shoulder on matters concerning trusts. And we are saying here, no civil or criminal proceeding shall lie against a trustee who in good faith discloses information as permitted under this Act. If we look to the Financial Intelligence Unit Act, Chapter 7201, Section 25, subsection 2, I'll read it out. No civil or criminal proceeding shall lie against a person who, in good faith, discloses financial intelligence or information under this Act. We are acting in tandem with what we've done. This law was amended 2011, that's the FIU Act, 2012, 2014, 2015, and that clause was never disturbed, you know, Madam Speaker, Madam Chair. So this is, lastly, this clause was actually amended in 2012 by the UNC. So if the FIU could have been treated with this way, by way of an amendment from the UNC government in 2012, how we could not be protecting a trustee in a similar way?
Member for Diego Martin Northeast.
To me, the operative words are at the end of the subclause, as permitted under this Act. Because the person will be disclosing it to a lawful authority, would not be disclosing it to Tom, Dick, and Harry. It's as permitted under this Act. And it brings in the good faith because you're not going to be lying to the lawful authority. You're permitted to disclose the information, and you provide the information in good faith. There's absolutely nothing wrong with this.
Madam Chair?
The opposition, and I
In those circumstances, member for Diego Martin East, who would be liable for any loss that may be sustained by the actions of a trustee?
Well,
who may have acted in good faith or bad faith?
I go back
Clause
to
43.
as permitted under this Act. Yes, as the AG says, but I go back to as permitted under this Act. So the information is being disclosed to a proper authority. It may be wrong, and as the AG says, the state is liable for
Which
any...
clause is that, please?
Clause 43, compensation.
Thank you, Madam Chair. I'm just curious to find out from the member for Siparia, why would this public officer, appointed by the president in the circumstances here, why should such a person be subject to personal liability? I'd like to hear that.
Madam Speaker, I have accepted Diego Martin's notice explanation, and shall we please move on?
All right. All right. So, might I, honourable members, just for us to, so member for Siparia, is it that you're withdrawing item 27?
Yes.
Or you're agree to disagree?
No.
You're withdrawing?
Yes, ma'am.
Okay, and the explanation. Can we then therefore invite you to, yes, to elucidate on item 28?
It's just a drafting little issue where I'm suggesting that such monies as may be appropriated by Parliament, we delete, and instead we just say out of the consolidated fund. So that's what that is basically. Look at 17 one now.
Madam Chair, I think that that's a sensible submission, that it goes to the consolidated fund, because the risk could be that you fail to appropriate it under a line item in the budget at any 1 year, and what it really ought to be is a charge on the consolidated fund.
Point up here, do you have a point?
Withdraw.
Okay. So,
it's the same thing, but it's a safer route.
So can I put a question now? The question is that clause 16 be amended as proposed by the Leader of the Opposition in terms of item 28.
3.
Item 28. We agree
Yes,
this item 28?
Yes, ma'am.
Yes? Those in favor say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 16, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Might I ask, no amendments have been circulated in terms of 17, clauses 17 to 30. Can we take them in a block? Yes, thank you.
Clauses 17 to 30.
The question is that clauses 17 to 30 stand part of the bill. The question is clauses 17 to 30 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 17 to 30 now stand part of the bill.
Clause 31.
And just so that we all on the same page, now at page 24. The question is that clause 31 stand part of the bill. And there are amendments proposed on both sides. AG.
Madam Chair, may I just, as a matter of housekeeping, we're now about to get into some of the crux amendments, and we're at 424. I'm wondering whether it would be a human relief if we could take the break subject to your guidance at this point, and then start the run.
I thought we had so much human relief already. But I think I get this sentiment from all involved that it's the humane thing to do. So I would say that we suspend this meeting now and we resume at 5 o'clock. Okay? So the meeting is now suspended. We resume at 5.